see here, how does this work? I got it right here, so just wherever they're at.
For right now, we're just doing the juveniles in the shelter, so these won't matter,
Okay,
because you're doing the juveniles.
Right.
And then when we're done,
Then they'll tell
I'll
me.
hit the other button, and then you'll use those.
okay,
Okay.
sounds good.
When that starts, when that comes on blue, we're ready to go.
Okay. Yes.
It's the same defendant there, last name Terry. And he has counts 1 through 3 on the first one, and the second one is 4 through 6.
Okay.
Just on that.
All right, well, when we get to them, just point out that it's one of the ones.
I'll let you know.
Okay.
Thank you.
All right, let's go ahead and get started. Clerk, you ready to go? Yes, sir. Madam Clerk? You ready? Okay. All right, the first, I guess we have the shelter hearing.
No, so we're gonna do juveniles first. The first person is. Ready, DJ?
Yes,
Come on, man.
Darius.
Last name?
All right, the first one I have is Jordan DeLello. Is that right? Ma'am, who are you here for? Darius, okay.
Good morning, Your Honor.
Morning.
Danielle Penn with the Department of Juvenile Justice. We have Darius Singh. This is his grandmother here. Mr. Singh is currently on home detention with electronic monitor from another state, and he wasn't supposed to leave the house. However, he did leave the house, and he got a new charge. Mom is on her way back here to Florida. They're transitioning from moving from Ohio to Florida. However, he does have a court date in Ohio on Tuesday. However, he did leave while the grandmother was sleeping, so that's a concern for her if he's placed back on home detention with EM, Your Honor.
He scores 10 points?
Actually, 8 points, Your Honor.
8 points?
Yes.
So that puts him on a home detention situation versus a, any type of 21-day hold?
Yes, Your Honor. I mean, I'm not sure how we could, if he's already on home detention in one state, if you would be able to put him back on here to allow him to go back to his court date in Ohio. Also, the concerns that grandmother has as well.
All right, let me hear from the grandmother. And if you would, ma'am, let me place you under oath. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right, tell me your name first.
My name is Ruth Rayson.
All right, so tell me what the situation is.
Well, Darius was at my house on house arrest, and when I was sleeping, he went out and caused some mischief and got himself in trouble. I have a plane ticket for him to go back to Ohio for his court date on Tuesday. His plane is on Monday morning. But, Your Honor, I'm a little concerned about him staying with me. I take care of my elderly mother, who's 96, recovering from a stroke. So I'm kind of.
What kind of trouble did he get into?
He had a grand theft, Your Honor.
Well, can you hold him until he flies on Tuesday?
On Monday,
Or
we may
What
need
time's
to-
his flight?
It's in the morning, it's 7,
7 in the morning?
something, I don't know the exact time, it's on my phone.
Yes, that's fine, Your Honor. We would need a court order just to hold him until, until we get ready to release him.
All right, can you, like, pick him up and take him to the airport?
Yes, I can.
Okay. So, can I order that he be released at, let's say, his flight's at 7, you believe? Yeah, go check.
Your Honor, while with the grandmother's doing that, I would just add that's going to be over domestic objection. He's scoring 8 points, he's entitled to release. I understand that the parent charged him right now to keep him, that's at the shelter, he's entitled to release. He would have to be kept for 24 hours. 8 points.
Well, he's on home detention in another state. Isn't that like being on probation and violating your probation?
We don't have the capability to.
I mean, he's a
We
juvenile,
don't
so.
have, we don't, I forget the terminology they use in the statute, that we don't have a space in between. In some jurisdictions, they have 3 options. That you could be on home detention, you could be something kind of in between, or you could be insecure. We don't have that middle space, so he would be entitled to the home detention that we only have violation of probation.
What offense does he have up in Ohio?
Your Honor, he's on home detention with EM for carrying a concealed weapon.
And you scored that, and he scores 8 points?
Yes, Your Honor.
What kind of weapon was he carrying?
I'm not 100% sure, Your Honor. It just says concealed weapon charge. It doesn't say if it's what type of weapon, if it was a knife or a firearm.
Yes, ma'am. What time's this flight?
It leaves Fort Lauderdale at 7:40.
Okay. What time can you pick him up to take him? Like 5 in the morning? 6? 6? All right. Can we order him released at 6 a.m. and make sure that it happens, or is that going to be something? If he's to be released to his grandmother's custody at 6 a.m. on Monday morning, day after tomorrow.
Just as long as it says it's on the court order, that's fine, Your Honor.
Okay. And they'll tell you where to go and all that to pick him up. All right? Yeah, 5:30? Okay. Where is he being released from, just so I can get an idea how far it is from the airport?
It's actually at the Broward Regional Detention Center. It's right off of Broward Boulevard,
So
so
it's
it's on the
close.
way to the
It's on
airport.
the, okay. 5:30, okay. And the public defender's objection is noted. Okay, who's next? Juvenile? Jordan DeLillo?
Your Honor, Mr. DeLillo was a direct admit to home detention. He scored 10 points on the detention risk assessment. He was actually a walk-in.
So all you need is a finding of probable cause at this point? He's not here. I guess we have to issue a pickup order.
I would ask Your Honor, if you maybe, sometimes they show up a few minutes late. So
Well, I'll
if you're
vacate it.
ready-
I'll issue the pickup order, and if he shows up before the end, I'll vacate it. How's that?
I was gonna have no objection, so if he shows up, we can.
Yeah. I'm not going to issue a pickup order if he shows up, even if he's late. Darren, is it Pubian?
Yes, sir.
Vehicle theft, grand theft of a motor vehicle, operating vehicle without a license. He scores 19 points, which is what, a 21 day?
Yes, Your Honor, 21 days secure.
Okay. Is he here?
He's in the back on the left, Your Honor.
Okay. Anything you want to say?
Some of the charges I ain't used, so I was just
There, I want to talk about that.
Yeah. All right, well, when you go in front of, when's he scheduled to go in front of his division judge?
He's scheduled to see Judge Robolo on July the 2nd, Your Honor.
All right. Mention to him that if you want to go on a, instead of remaining in jail or in juvenile detention, mention him that maybe you want to have the monitor put on so that you can be released. Okay, if you want to do that, just mention it to him because I think he will do that.
The only thing I would ask, Your Honor, if that's your intention, when you sign the order, there should be a spot somewhere on there checking, that the division judge should approve. You don't check it.
I'll do that.
Say that the judge-
All right, I haven't seen any orders yet to sign, so when they come through, I'll check that on him. I'll put it over here. I thought the division judge could always review it, but,
Their tendency is the detention judge does not check that we review the wall. So
okay,
you have to signal that you're okay with the division judge review.
okay. That was my division. That used to be my division anyway. The juvenile division that Robolo has. Okay, how about, are we ready yet for the shelter hearing?
Gotta get these juveniles out.
Okay.
Judge Forsay, you said you wanted him released Tuesday morning, that same day of the flight, correct?
Monday morning.
Monday morning.
Monday morning at 5:30
Okay.
to his grandmother, and so that he can catch a
I
flight.
said Tuesday, but I wrote Monday morning.
Okay.
It's right there on the order.
All right, and you have her name on there, or do you?
No, I didn't get her name, but I have her mother. Is she still here?
Yeah, you want to.
She didn't say her name.
What was the grandmother's
Her
name?
name is Ruth. Let me get her last name.
Yeah, just add that over there where it says grandmother, so that there won't be any confusion by them, and they go, well, prove you're his grandmother.
R-A-Y.
Yeah, and here's the order, so you can put it right on the order, okay?
I just wrote it upstairs.
Okay. Now, I'm looking at the order on Darren Pubian, and I'm looking for that check mark he said I could put on here.
Well, you see Judge Robolo's name?
Yep,
That's it right there.
there it
There's
is,
no check
okay.
mark. I just had to write it.
Oh,
There's no check mark.
Okay, there's that one. So that's done. All right, are we ready for the shelter? Is that the next item? Yep.
Yep, finish with juveniles.
That's pretty fast. Okay, it looks like everybody's ready to go. Raya Velsor?
Mike McGee, Assistant Attorney General for the department. We are here today on a Chapter 39 proceeding for a dependency hearing for Raya Velsor. We did give the shelter a petition. I do have the CPI here to swear to the petition at this time, as well as take brief testimony.
All right, raise your right hand if you're going to testify. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, if you would start with your name, and then I guess counsel's going to question you, so.
Okay, and were you the CPI officer who removed the child?
Yes,
Okay, and you filled out a COD related to the removal of that child?
yes,
And did you go through the petition that was given to the court? Do you swear to the items therein?
yes,
Okay, specifically, mother's not present today. Did you speak to the mother?
yes,
Okay, was she informed about the proceeding here today?
yes.
What was she informed?
The child will be removed from her custody as well. There will be a shelter hearing Saturday morning, courthouse at 8 a.m.
Okay. At this time, Your Honor, I would stand on the four corners petition. I can take additional testimony, but we do have a putative father present. If we could do a colloquy as to the putative father.
Okay.
Mr. Travis Velsor, at this time, your putative father, would you like to establish paternity as the child, or? Okay.
All right, let me place you under oath, sir. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, you may inquire.
Okay, so this mother had previously named you, and the child does share a name in common with you. You are not on the birth certificate, but you're saying Ryo Velsor is your child to your knowledge?
Yes.
And at this time, you would like to establish paternity, including obligations of support and everything that goes along with that?
Yes.
Okay. At this time, Your Honor.
And he'll have visitation as well, per the petition that I read.
Yes.
Supervised.
Supervised.
Yeah. Let me ask you this, have you tried to place the child with a relative?
Yes, we do have the child placed with the maternal grandfather.
Okay.
We submitted a home study. Ms. Ramjeet, have you also, or, I'm sorry.
Manuela Singham-There. I'm the one who completed the home study with the maternal grandfather.
Okay.
As to that placement, is it safe and stable for the child?
Yes,
Okay, and you're asking the child be placed there today based on the approved home study?
that's correct.
All right, and sir, let me get you to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, tell me your name.
Alfred Miller.
All right, and the child is almost 3 years old, right? All right, and you can take care of the child until this matter's resolved?
Yes, sir.
Okay,
Your Honor, may I?
yes.
Grandma's also in the picture.
Because I'm going to object to the shelter hearing, Your Honor, if I may.
Sure. All right, first of all, tell me who you are.
Jeanette Watkin, I'm the attorney for the now established father.
Okay,
Your Honor, the law is Florida statute 39.402, placement in a shelter, states, under subsection 1, unless ordered by the court under this chapter, a child taken under custody shall not be placed in a shelter prior to a court hearing unless there is probable cause to believe that, subsection A, the child has been abused, neglected, or abandoned, or is suffering from, or is in imminent danger of illness or injury as a result of abuse, neglect, or abandonment. That's the standard. Now let me just go through the facts of this case, and then I'm going to apply case law for Your Honor to make a decision. The facts of this case are, the mother dropped off the child to the father for the last 3 weeks because the mother was going into a rehab on her own. The father took the child, and the child has been with the father for the last 3 weeks, with the father and the fiance. The child has been well taken care of, has been fed properly, bathed, everything, Your Honor, bathed, fed, taken to school. She was even changed to a brand new school, which was much better for the child. The child was historically kicking and retaliating against other children. The child is now sleeping on time at 7 o'clock at night, as a normal child should. Unfortunately, the mother, who has an issue with substance control, was not able to do that. She dropped off the child to the father, and the father has taken care of this child for the last 3 weeks. So what happens? The mother decides to come out of the rehab and go pick up the child. And the father said, no, I'm not going to give you the child. The child's well taken care of, and you're in no condition to take care of this child. So what does the mother do? The mother calls the police
I'm going
to
to
pick up
object
the
at this
child.
time, Your Honor.
Wait,
Reporter information is protected information. Not only are we getting into allegations by the attorney, I don't have any evidence of this, but specifically stating who called the abuse hotline is protected information.
I'll withdraw that portion. I'll withdraw who called who. We'll take that part out. The fact of the matter is, Your Honor, that what the shelter hearing is saying, the purpose of their allegation is that the father has drugs in his system. But under case law, that's not sufficient for a shelter hearing to remove a child from the custody of his parents. Specifically, to prove there is an imminent, and let me state which case I'm referring to. That would be JB3 versus Department of Children and Families, 928 Southern 2nd, 392, 2006, First District. And it states, and may I give your honor a copy?
Sure.
May I approach?
Yes.
I'm quoting.
Just give it.
Yes, and I'm gonna give him one also.
Great.
Specifically, Your Honor, on the back page, it says, to prove there is an imminent risk a child will be abused or neglected, DCF must offer competent, substantial evidence that abuse or neglect is impending and about to occur. If there's no nexus between the parents' alleged behavior and the likelihood the child will suffer abuse and neglect, then a finding that abuse or neglect is impending or about to occur cannot be upheld. Just the mere fact that the father, who by the way submitted himself to a drug test, voluntarily has marijuana and Percocet, or I think it's called oxycodone, is not sufficient to show that he cannot take care of his child. In fact, he has been taking care of his child, been bathing her, feeding her, taking her to school, clothing her. This child is super well taken care of. She has her own room, she has her own bath. There is no impending. This child, the mere fact that the dad had this in his system, like I said, is not sufficient to remove this child from his home where he's properly taking care of her and putting her somewhere else. So I'm gonna ask this court to deny the shelter petition and grant my client a temporary, for now temporary custody of the child with him.
Did you do what is your study of the father's home show in terms of the care of the child?
Your Honor, upon the commencement, the father was at home. I made contact with the child at the school, and I made contact with the father at the office the next morning. So I have not been able to enter his house to assess the use of marijuana.
All right. How about the child? It's a boy, Raya?
It's a
Girl?
And Your Honor, if I can just interject one small thing. At the time that the mother called the police came, sorry.
Again, that's protected information.
And it's
Okay.
hearsay as well. Your Honor.
Okay,
We don't
I'm
have
sorry,
any-
I will remove that part. When the police came to the home and did an inspection of the father's home, they left the child with him because they found that the home was proper and suitable for the child.
Don't have any
That's Hollywood Police Department.
information
Called
to
Hollywood
that.
Police and had Hollywood Police in the house. They came in the house, looked through the whole entire household, and said that the child is fine.
Okay, and what's the condition of the child? Well fed, well nourished, bathed, nothing they can.
The child appeared to be fine, but I'm not a medical examiner, so I wouldn't be able to attest to her.
Yeah. Have you, but you haven't been able to do a study of the father's home at this point?
No.
Okay.
Come right now.
And, Your Honor, if I may respond to
Sure.
counsel's.
So why not do a study of the father's home? I mean, the allegation is that he has oxycodone and takes oxycodone, but I mean, what's your response to the argument that that's not abuse in and of itself?
The argument that's not abuse in and of itself, the case that's being relied on out of the first appellate is
First DCA.
specifically, it's specifically talking about the admitted use of marijuana, but not in the presence of the child. We have other substances that have been alleged. Father's currently on probation for cocaine. We have the history of the drug use, including father's statements by the officer that father had relapsed recently. Based on the recent relapse, the allegations that the girlfriend who resides with father is using Percocet in front of the child.
I'm sorry, I object to that. There's no allegation. There's no allegation
It's
that any
in
of the
the-
abuse is in front of the child. None whatsoever.
It's in the shelter petition. I can also have my officer speak to it. In addition, this case is relying on a dependency proceeding as to dependency adjudication. We're here today for a shelter proceeding, the basis of which is a probable cause hearing. The department's argument that is based on the allegation of the drug use, the father's past criminal history record, that there is a current DV injunction, which based on the transaction between the father and mother, by their own admission, sounds like was broken by making contact between the mother and the father to give the child over. The department's saying that there's a problem.
Is the mother an ex-girlfriend or a current girlfriend or a fiance or?
The DV was removed though. Eric Schwartz is my criminal lawyer. They had the DV removed.
I only have.
I mean, is she an ex or is she a current?
She's an ex.
Okay.
I'm engaged to get married.
Okay.
So based on those allegations, as well as the substantial history of drug use, the admission as to using drugs in and around the child,
Where's the child now?
the child's with the maternal grandfather.
Okay.
And Your Honor, if I may, the fact that the father has historically used drugs also is not sufficient because in April 2018, as stated in his petition, the father completed a substance abuse program, and the father had not been using any of the hard drugs that he had historically used. Now, what he had in his system was the marijuana and the oxycodone, which is nothing enough to impair the ability to care for a child. And he has in fact shown that it hasn't because he has been taking care of it for the last.
When would, if I do shelter the child at this point, when would that be reviewed?
There would be an arraignment hearing. You could put in a denial to the petition, and it would be at the first dependency adjudication hearing.
Which would be about when?
Based on time standards, it depends on the calendar, Your Honor, but the arraignment would have to be, I believe, within 30 days, and from there, I think it's 60 out for the time trial, or 45 out for the actual trial from the arraignment.
Your Honor, if it's possible, if you could put the child back with the father.
I won't do that unless they do a home study for the father, and look at the father, the situation there at this point. I'm going to just sort of stabilize the situation here, shelter the child until there can be a hearing on probable cause, and then you can go through everything at that point and go from there. And the father has visitation rights, under supervision, so he's not going to be isolated from the child. It's just a question of temporarily having the situation, just to be sure. And he might be right. I mean, it might not interfere with his care of the child, but they've established enough here to shelter the child at this point.
So right now, we're gonna leave the child in the shelter
Yeah.
with the grandfather?
Right.
Until we can do a home study of the father's house?
Right, until they can make a determination as to the father's house, okay?
That's the father's house.
And Your Honor, procedurally, the clarification I'm going to need is this shelter hearing would procedurally be the probable cause hearing as to that removal?
Yeah,
By
there's
statute,
probable cause.
We can't, okay. Well, that's what, it wouldn't be,
But I want you to set this in front of the division judge that would usually make this determination.
okay.
And I know
counsel
they
can't file a
regularly hold
motion as
hearings
to-
because they try to reunite the child. Thank you. They try to reunite the child with the parents as much as possible, and I know they constantly review this. And they'll have more information on the father's home at that point, which they don't have at this point. Everything they have at this point is bad.
Arrange the visitation?
What's that?
How does the visitation work? Do me and him arrange it? To where I can come see
I'll
the
ask-
baby?
We would be specifically asking supervised by department or designee. So the department can supervise visitation. In addition, if the grandfather is cleared as a designee, then he's able to supervise as well.
Okay,
So
so he could give you permission after he's cleared by them, which I'm sure will be pretty
We would also
routine.
be asking for a medical release as to the child
Okay,
to verify.
granted. That way they can make sure the child's fine and get any medical treatment, okay? All right, hopefully it'll work out for you, all right? All right. All right, I guess at this point,
I'm sorry, I was just told that the juvenile came in.
Oh, he is here.
He's on home detention.
all right, yeah, he's
You want me
really,
to prepare an order for home detention?
yeah,
They
let's
can
call it,
pick
let's
up
recall it just to make a record of
And
it.
I'll give him his court date.
No, one more juvenile.
Yeah, yeah, walk in, all right, this is Jordan DeLello. Jordan DeLello. He must be outside.
Yeah, she's gonna get him right
That's the
now.
new
Okay.
order. to vacate.
All right, this is Jordan DeLillo.
Good morning, Your Honor. This is Jordan DeLillo and his mom. They were
Okay.
running late, it's a bad accident on 95, Your Honor.
Yeah. All right, no problem. Everything's good? Okay, you were late, so I had issued an order to pick up, but I'm going to vacate that order right now, and you'll continue on home detention. Everything's under control at home? Okay. Great. Then you're all set here. Wait for a copy of the orders, okay? And ma'am, I can tell you it makes a huge difference when, you show up and, can give your input to the court. So any chance you have a court hearing, please come in to the court and explain the status, okay? All right, all right. All right, there's the original app. I missed juvenile. That was... All right, I guess we're ready to go on with a regular docket at this point. Okay. Let me just, before we get started, let me, Madam, let me just see, do we have one of these orders available? Ginger, I'm gonna run a second, do we have one of those orders available? Order for emergency psychiatric screening to be performed by Armor to assess for Baker Act. Yeah, maybe I can order a Baker Act. Oh, we have that one child, or the one adult who's got autism and a mental health issue. It's the third one on the docket.
You think they're very
Yeah.
serious, just because.
All right.
Good morning, Your Honor. Spanish interpreter is present.
Okay.
Luz Angela Lopez, it'll be easy.
All right, let me place you under oath. Do you solemnly swear to truly and accurately translate from Spanish to English and English to Spanish?
I will, Your Honor. Luz
All right.
Angela Lopez, it'll be easy, certified Spanish interpreter for the courthouse.
Okay. All right, I guess I'll call the docket. I got them up here, so I might as well do that. The first one I have is Mr. Sanchez. Is it Sanchez? No, Contreras. Selima Peña Contreras. North Broward, okay? Okay.
Señora Peña Contreras?
Morning, Your Honor.
All right. All right. Ma'am, you're charged with domestic violence battery,
Señora, la acusan de violencia intrafamiliar, de agresión física.
and that's a first-degree misdemeanor,
Ese es un delito menos grave de primer grado
punishable by a maximum of a year in jail.
y podría ser castigable con hasta un año en cárcel, perdón, como pena máxima.
And I'm going to find that there's probable cause.
Yo hallo que hay motivo fundado para detenerla.
Okay, recommendations?
Recomendaciones.
Your Honor, I do not speak Spanish, so to be honest, I've been unable to speak to Miss Peña Contreras as of this morning.
Señor juez, yo no hablo español, habla el señor abogado, abogado defensor, no hablo español y no he podido comunicarme esta mañana con la señora Peña.
I only have access to Broward cases. I do not see any Broward priors whatsoever.
State any priors?
El señor abogado defensor habla de nuevo, señor juez. I am so sorry, counsel.
You're unable to check? Any other states you're saying?
El señor abogado defensor ha dicho que él no puede ver los casos, solamente los casos del condado de Broward y no ve ningún antecedente. El señor fiscal le dice al señor juez, tenemos que mirar en el sistema y todavía no hemos visto nada.
If there are no relevant priors, Your Honor, what I'll ask for is non-monetary release. Additionally, according to the probable cause, there are children in common. I would ask for third-party contact to deal with custody of the children.
Señor abogado defensor habla de nuevo. Señor juez, I'm sorry, counsel. Señor juez, no hay, parece ser que no hay antecedentes que sean relevantes a este caso. Por eso le pediría al señor juez que por favor lo deje en libertad bajo una condición que no sea monetaria. usted tiene hijos en común, quisiera pedir que le den permiso de ver los niños a través de una tercera persona.
And Judge, I do not see any Florida priors. At this time, we'd be asking for a $250 bond and no victim contact with the victim's initials being JD.
El señor fiscal habla, señor juez, no vemos ningún antecedente aquí en la Florida. Quisiéramos pedir que le impongan una fianza de $250, que no haya contacto o comunicación con la víctima, que tiene las iniciales JD.
Is there, what's the relationship with the victim? Are they, they've been married for 4 years and have 2 children in common, so it's her husband at the present time?
El señor juez pregunta, ¿cuál es? I am so sorry, Your Honor.
What's the relation, are they
Yes,
married?
Your Honor, yes, Your
Just,
Honor.
are they married?
Yes. El señor juez pregunta, ¿cuál es la relación familiar que tiene usted para con la víctima? ¿Están casados? Dice que tienen 4 años, están viviendo juntos y que tienen 2 niños en común.
Is that right?
Perdón, señora, ¿sí?
Sí, estamos casados.
Yes, we are married.
Okay. And the house at 103 Laurie Lane in Pembroke Park, is that your house, his house, or both your houses?
Señora, la
Casa.
dirección que da el señor juez de 103, I'm so sorry, Your Honor,
Lori, L-O-R-L-I.
Laurie.
Lane.
I'm so sorry, Your Honor, the interpreter was not able to get the whole address. 103 Laurie
Lane,
Lane, thank you, Your Honor, en
Pembroke Park.
Pembroke Park. Señora, la casa que está en la dirección 103 Laurie Lane, Pembroke Park. ¿Esa casa es suya o qué?
Es de mi papá, pero él me dejó vivir ahí con mis hijos y él.
This is my father's house, but he allowed me to live there with my children and him.
Okay. I'm going to release her on pretrial release.
El señor juez habla, estoy dispuesto a dejarla en libertad bajo los servicios especiales de la corte.
Yeah, I think it's standard pretrial. She's got no prior record, so just pretrial release, and she'll have to report to pretrial release, and they'll get all the information and give her the information on how to stay in touch with them. And
La señora de los servicios especiales le pregunta al señor juez si que la dejen en libertad bajo los servicios especiales de la corte estándar. El señor juez dice que sí, debido a que usted no tiene antecedentes. Usted debe reportarse o presentarse a esa oficina de los servicios especiales, la van a dejar en libertad. Pregunta el señor fiscal si no debe tener contacto o comunicación con la víctima.
how about no violent contact?
El señor juez dice que en vez de ser no contacto con la víctima, que no haya contacto o comunicación violenta con
You understand you can't fight.
la víctima.
If you're going to fight, you got to walk away.
Señora, usted entiende que usted no puede pelear con él. Si es que van a empezar a pelear, usted debe salirse y alejarse.
Okay? If you don't do that, you'll be in violation of your pretrial and be back in jail.
Si usted no cumple con esa orden de alejarse, si es que va a haber alguna discusión, alguna pelea, entonces usted estaría quebrantando esas condiciones por las cuales la están dejando en libertad y regresaría a la cárcel.
And don't let me down. Don't get into any fights.
Por favor, señora, no me decepcione, no se meta en peleas.
Okay.
This one?
Okay.
Okay, you just need it.
Your Honor. Sign it and I'll just write everything you ordered.
The interpreter explained to her this is a map to the pretrial office, and it is in Spanish.
Señora, el señor alguacil le está entregando a usted ese documento, ese mapa donde se debe presentar y ese documento está en español.
There you go. Okay? All right.
¿De acuerdo,
Thank you.
señora? Gracias, señora. La señora de los servicios especiales le va a tomar la información en cuanto a cómo se debe presentar allí. Your Honor, the interpreter was just telling the defendant
Gracias.
how that the pretrial representative will talk to her.
Okay.
One within the state would request no victim contact. I think you said no harmful contact.
Yeah, they're married.
The
And
state
she's
would
got no.
object to that. It's just, it's very hard to monitor, control. I mean, the state would be asking for no victim contact.
The victim could basically initiate an investigation by making a call. So, and they're married. and there's no priors, so,
El
I'll just say
señor
no
fis-
violent victim. You know, when you get married, that gives you consent to spend time together. So,
El señor fiscal le pide al
hopefully
señor
it's,
juez
good
que
time,
él
not bad.
protesta o se opone a que le permitan contacto o comunicación con la víctima, aunque sea ordenado que que no haya violencia, porque dice que es muy difícil monitorear o vigilar esa situación. El señor juez dice que ustedes están casados, usted no tiene antecedentes y que simplemente la víctima puede empezar o iniciar una investigación en cuanto a si hay de nuevo violencia.
By calling,
I'm so sorry, Ana.
by calling.
Esa víctima puede llamar y pedir que se inicie una investigación.
And if that happens, she'll be she could be in violation of
Y
her.
obviamente si la víctima hace eso, quiere decir que usted estaría quebrantando
Could be.
esas condiciones.
She could be.
Podría estar quebrantando esas condiciones.
Okay, thank you.
¿De acuerdo, señora? Ok.
Okay, I guess next is Randall Gall.
She's a medical reset, Your Honor. That's it.
We just passed.
Medical reset.
Okay, well, I already signed
I
it.
know, it's okay, I'll just,
Okay.
you'll be good.
Due order, let's do an order for
Since he's already in medical, I don't think.
He's medical, yeah, he'll be here tomorrow, he's
Okay.
gonna be reset tomorrow.
All right.
Is this the one you was talking about, though?
Yeah, this is the one I was
Oh,
talking
okay.
about, that Ginger Lerner Wren was nice enough to, when I asked her to send me an emergency order. You might want to get that for tomorrow. It's called an order for emergency psychiatric screening to be performed by Armor to assess for Baker Act. Tell you what, if at the end of this, if you give me your cell number, I'll text it to you so you have the order.
Okay.
Okay?
You're not gonna be the judge tomorrow?
I am.
Oh, so if he comes through, I don't know.
Yeah, maybe I can just print it up at home and bring it with me tomorrow if he comes through tomorrow, okay? All right, next is Brian Brown. I'm gonna find there's a probable cause.
He is in Maine.
Main jail, all right, let's see. All right, next is Brian
Phil
Brown,
Johnson at the main jail with the PD's office.
okay?
Okay.
Brian Brown, looks like there's probable cause. It's a domestic violence case and a resisting officer without violence. Recommendations.
Mr. Brown could afford a $300 bond. That would be about as much as he can afford.
Okay. What's the, go ahead.
So it's a domestic battery charge. He's employed. He's lived here his whole life. He has a son and granddaughter here. We'd also be requesting a photo order. That's essentially.
All right,
That's
state.
And
What would
Judge,
be requested?
Your Honor, the state's seeking a $1,000 bond on each account, and that's mainly because of his priors. He has two previous battery priors, both of which were in 2007. He also has,
When, 2007?
yes, Judge, as recently as 2013, he also has delivery and selling cocaine with intent. He was sentenced to 5 years. As far as violent offenses are concerned, he also has a robbery, a 1988 robbery with a firearm, a 1983 robbery with a firearm, and a 1985 robbery with a firearm. He was sentenced to 12 years on the 1988 robbery. And for the reasons stated, Your Honor, again, the state's seeking a $1,000 bond on each. And also due to the facts of this case, Your Honor.
You can afford. Yeah, he can make bond, Your Honor.
Okay. He can make $1,000 bond?
Yes, he can.
All right. How about no contact with the victim? What's the status there? The victim's his girlfriend.
Yes, we also ask for no victim contact with the victim's initials being ZB.
Yep.
Y'all be quiet.
All right, no contact with the victim.
Yes, sir.
All right. And contact means phone calls and texts and all that. That includes all that. Or having a third party contact him, okay?
Okay. And We're requesting a photo order, Your Honor.
A what?
A photo order for his injuries.
Okay,
Judge, that was $1,000?
$1,000 bond. Yep.
Count one? Yes.
No, that's.
Yeah, on count one.
Yeah, we just gotta make sure paperwork is
Keep,
correct.
keep it 0 on
Yeah,
count
we're gonna
two.
leave that. We're not
Okay.
leaving that.
You bet.
All right, that's it.
Oh, yeah, yeah, when you're done, you guys can head out.
Okay, next is Jason Patterson. Where's he? Okay.
Yeah, right after on the bench.
All right, any argument on probable cause? All right, I'm gonna find,
No, Your Honor.
all right, I'm gonna find probable cause and recommendations.
Your Honor, we, move forward anything at all.
Yes.
Your Honor, defendant can afford up to a $5,000 bond. The 500, you coming up.
So what do we got here? We've got,
It's not showing.
we've got a second-degree misdemeanor, a first-degree misdemeanor. Looks like it's all misdemeanors.
Yes, Judge, we have 2 first-degree misdemeanors, actually. They would be seeking a $500 bond on each count, Your Honor.
Okay. I'm gonna set the standard bond, if there is such a thing anymore, of $500 on count 1 and $500 on count 2, and it'll stay, he won't have to post a bond, it'll be ROR'd on count 3.
Also, no victim contact, Your Honor.
That would be acceptable, Your Honor.
And who's the victim in the case?
Initials ND.
Okay, is it a police officer?
No, Judge. It's not a police officer.
Okay. Any input on victim contact from the defense?
No, Your Honor.
All right, no victim contact.
Requesting a photo order, Your Honor.
Okay.
Thank you.
All right. Do you need that shelter paperwork as well?
Yes.
All right, there's that. This is just the case law. All right, we can go to the next person. And that is Stephen Petit. Any
Bonded
ar-
out, Your Honor.
Bonded out, okay. All right, next is Paul Jr. Aggravated assault with a deadly weapon, domestic violence, possession of a weapon or ammunition by a convicted felon, touching or striking, battery, domestic violence. I'm gonna find probable cause, and what are the suggestions here? Let me hear from the state first.
Second, sorry.
State? He's gotta have a prior if it's possession of a firearm by a convicted felon.
Yes, Judge, she has a 2017 burglary of an unoccupied dwelling. 2007, sorry.
Is that it?
And he was sentenced to 1 year, Your Honor. He also has a 2008 false name. And yes, Judge, that's it. At this time, on count 1, the state's seeking a $5,000 bond. As for count 2, Your Honor, state's also seeking a $5,000 bond. And as for count 3, Your Honor, state's seeking a $500 bond.
All right, defense?
Your Honor, I had trouble hearing that last part. The
Sure. 5,000,
500.
5,000, 5,000, and 500, for a total bond of 10,500.
Okay.
All right, so I'm going to set the bond at 5,000, Yeah, 5,000, 5,000, and 500. Okay? And no victim contact.
Okay, Your Honor. Understood.
Okay, next is Leonard McKenzie.
Your Honor, as Mr. McKenzie's walking up, Mr. McKenzie has alerted us that he does have private counsel, and he wants to have private counsel on this case. Private counsel is not currently present. I don't know if we want to hold this maybe till the end of the docket, see if his counsel shows, or if we just want to reset this now. I would leave it up to Your Honor.
Is he expecting his attorney to show up here today, or he needs to contact him?
Well, I gotta contact my attorney, but I wanted to sign for a PD for my additional charges, but I was rushed, so I ain't really get a chance to.
So what I would ask Your Honor to do, most likely to reset this for Monday. From what I can see, he has no bond holds anyway, so he's not being prejudiced if
Okay.
we do that. And so I'll give his attorney a chance to come. So I would ask to reset this for Monday.
All right, I'll reset it for Monday including, for Monday. He's got a no bond hold anyway at this point, so I'll reset the probable cause affidavit, the probable cause determination for Monday. State any objection?
No objection.
All right. All right, next is Denzel Samuel. Ag battery with a deadly weapon and ag assault with a deadly weapon. And it looks to me like there's probable cause. Any arguments on probable cause?
No, Your Honor.
Okay, I'm gonna find probable cause. State recommendations and priors.
The defendant has a 2013 trespass adjudication, also 2018 pending drug paraphernalia. Your Honor. That's it. That's for Broward priors. As far as the recommendation,
You done, man?
state seeking a $5,000 bond. As for count 2, state seeking $2,500. Your Honor.
Okay, let me just, So this was an argument between he and his father, according to the probable cause affidavit. Physical altercation. Okay. I'm going to find probable cause, and I'm going to follow the state's recommendation, which was what again? 5,000 and 5,000?
2,500 on count 2.
All right, 5,000 on count 1, 2,500 on count 2, and no contact with the father.
Initials TS.
Your Honor, the defendant could make bond, but only at a maximum of $5,000 bond.
What are his priors again, state? I'm sorry.
He has a 2013 trespass adjudication and a pending drug paraphernalia case, Your Honor.
All right, I'm going to set the bond at 2,500 on count 1 and 2,500 on count 2. So that his total bond will be $5,000, okay?
Thank you, Your Honor.
Yeah.
Could we get a photo order on him as well?
For photos?
Photos
Photograph.
for injuries?
Yes, sir.
Thanks so much.
Yep. Okay, next. Jorge Trujillo Saavedra.
We need a Spanish interpreter for the main jail.
Okay. All right, I'm going to find, well, he's got, here are his charges. Touching or striking battery in a dating violation. Sexual assault.
I'm so sorry, Anna.
Okay, let's start with sexual assault by a 24-year-old or older and a victim of under the age of 16.
Señor, lo acusan de agresión física con la persona que estaba saliendo. También lo acusan de intento de agresión sexual de la persona que tenía 24 años y la víctima de 16 o 17 años.
No atento, es actual, not an attempt. It's an actual sexual assault.
Your Honor,
It's a sexual assault.
assault is intent.
Okay. All right. And present is who, ma'am, what is your name?
¿Cuál es su nombre? I am the aunt.
Okay. What is this, is this a second or first degree felony?
Está preguntando
It's a second,
al juez si es
Second
primer
degree.
o segundo
Yes,
grado.
sir.
So he has 3 second degree felonies?
He has 2 second-degree felonies and
And
the
a third.
batteries and misdemeanor.
Battery misdemeanor, okay.
Tiene 2 delitos graves de segundo grado y un delito menos grave de. I'm so sorry, the misdemeanor was second degree or first degree?
First degree.
De primer grado, el delito menos grave.
All right. All right, well, I'm gonna find probable cause.
Hay motivo fundado para detenerlo.
And, state what's your recommendation?
Your Honor, seeing the
No
defendant-
priors?
No priors in Florida as far as the state can see, Your Honor. However, due to the facts of the case, as for count 1, the state's seeking a $1,000 bond, and as for counts 2 and 3, state would be seeking $7,500 for each.
I'm so sorry, Your Honor. 1,000 for first and 7,500 for 2 and 3.
Yes, that's correct.
El señor fiscal dice que no haya antecedentes penales en la Florida, pero que debido a los hechos de las acusaciones sugiere que impongan una fianza de $1,000 para la primera acusación, $7,500 para la segunda acusación y para la tercera acusación.
Okay. Let me place the aunt under oath if I
Voy a
could.
ponerla bajo juramento.
Or okay, translate for him and I'll, all right, do you solemnly swear to tell the truth, the whole
Usted
truth, and
jura
nothing but the truth?
solemnemente o afirma que el testimonio que dará será la verdad, toda la verdad.
Yes.
All right.
May the interpreter inquire as to whether the aunt requires a Spanish interpreter?
No, that's all right. She'll understand you when you translate to him anyway.
All right.
So we don't need to translate twice. All right, you can put your hand down.
Baje la mano.
Okay.
You
Um,
cannot really interpret, I'm sorry.
Your Honor, I'd like to ask you.
Cannot interpret simultaneously, otherwise it wouldn't be possible, Your Honor.
Right.
So the interpreter has to wait for everybody, each person to speak, and then the interpreter will.
Right, and there's a lot of background noise.
Yes, Your Honor, thank you.
Okay, ma'am, has Jorge always lived in Cuba? I mean, I'm sorry, in Cuba. Has he always lived here in Florida?
¿El señor acusado siempre ha vivido aquí en la Florida?
No, él estuvo en Tennessee. Donde otra familia.
No, he was in Tennessee with another family.
Okay, and when did he move to Florida?
¿Y cuándo se mudó a la Florida?
Hace un mes.
A month ago.
Okay. Are you aware of any prior offenses?
¿Tiene usted conocimiento de que haya algún antecedente de algún delito?
No, él es un muchacho tranquilo.
No.
Ha sido un buen muchacho siempre, desde pequeño. Yo diría más bien que él es pasado de bueno y por eso de pronto
Momento,
le
sí.
pasa todo.
Your Honor, may the interpreter inquire as to clarification as to the term tranquilo. Señora, ¿qué quiere decir con tranquilo?
No es violento, nunca lo ha sido.
Okay. Yes, the interpreter has clarified the word. No, he is a person who's not violent, and actually I would think that he's just too good. Perdón, señora, ¿y que es muy bueno y qué?
Ha sido tranquilo.
He's always been non-violent.
Okay. And how long has he resided with you?
¿Cuánto tiempo hace que vive con usted?
Lo que hace que vino de Tennessee, mes larguito, mes y medio diría exactamente.
Since he came from Tennessee, I would say a month and a half.
Okay, and are you willing to have him stay with you?
¿Y usted está dispuesta a dejar que él viva con usted, esté con usted?
Sí, exacto, sí.
Yes,
No,
yes.
él no es de problema.
He gives me no problems.
And let's see, I looked at the pretrial release, and it looked like he had a pretty good It's a good candidate for pretrial release?
El,
Okay.
el señor pues dice, estaba mirando en cuanto a las condiciones para dejarlo en libertad bajo los servicios especiales del tribunal y parece ser que usted es un buen candidato. La señora de los servicios especiales habla, le dice al señor juez, sí, señor juez, si usted lo pone bajo la supervisión de los servicios especiales de la corte, nosotros lo supervisaremos.
Pretrial or the state, do you know where the victim resides? All right, state, do you have that information? I don't need an address, I just need to know,
El señor juez pregunta a la señora de los servicios especiales
Pompano Beach?
Yes, Judge.
All right.
o al fiscal si saben dónde está la víctima. El señor fiscal dice que vive en Pompano Beach.
And ma'am, where do you live?
Señora, ¿y usted dónde vive?
En la 8767.
8767
Northwest,
Northwest
6th Street,
6th Street,
Coral Spring.
Coral Springs.
Okay. All right, well, I'm gonna order him into pretrial release with a monitor and residing at the address that the aunt just gave.
Voy a dejarlo en libertad. Momento, señor.
Is that where he presently resides, or does he have his own place?
Voy a ordenar, dice el señor juez, voy a ordenar que lo dejen en libertad bajo los servicios especiales del tribunal con un monitor y que usted va a residir en esa dirección que dio la tía.
Is that where he lives now?
Esa dirección que dio la tía, ¿es allí donde usted vive?
Where he lives?
Yes, Your Honor.
Okay. All right, so he'll stay at that residence and he'll have an electronic monitor.
And Your Honor, and the state would object, understanding that he has no priors, still the severity of the case, the age of the defendant, the age of the victim, and also the fact that he lacks ties with the community. The state would object to pretrial release and still ask for $5,000 bond on count 2 and 3 and $1,000 on count 1, Judge.
Yeah, I'm gonna order him on a monitor. Oh, letter translate.
1,000.
El señor fiscal habla, dice, señor juez, yo protesto en cuanto a que lo dejen en libertad debido a la severidad de las acusaciones, la edad de la víctima y que usted no demuestra tener lazos para con la comunidad. Pide que por favor le impongan una fianza de $1,000 para la primera acusación y $5,000 de fianza para la acusación 2 y para la acusación 3.
I certainly would.
Voy a, la señora de los servicios especiales pide al señor juez si él va a ordenar que no haya contacto o comunicación con la víctima. El señor juez dice, sí, voy a ordenar que absolutamente no haya contacto o comunicación con la víctima.
I don't see a signature page.
Also, y'all know that you complete level 1 house arrest, or will you be allowing him to go to work, to go to church?
Oh, yeah, I'll be letting him do all that. Just level 2.
Entonces pregunta la señora de los servicios especiales, señor juez, y esa libertad bajo los servicios especiales de la corte será de completo casa por cárcel. Dice que no, que le permite que vaya a trabajar, que vaya a la iglesia, a la escuela. Dice el señor juez, sí, ordena todo eso. O sea, le permite, entonces lo dejan en libertad bajo los servicios especiales de nivel 2.
All right, anything else?
That's it, Your Honor.
All right, thank you.
I'm sorry, he's ROR in pretrial, or you set bond?
No, I didn't set a bond.
Okay,
He's
just
just
wanna make
released.
sure he's ROR,
Level
because I didn't-
Señor, entonces está repitiendo el señor juez. Lo van a dejar en libertad bajo los servicios especiales del tribunal. Dice que no impone fianza, sino que lo deja bajo esos servicios especiales con ese monitor, ¿de acuerdo?
Okay, thank you.
Gracias.
All right, Larry Bimbo is next. Any arguments as to probable
There's gonna
cause?
be a medical reset, Your Honor.
Medical reset, okay. I'm gonna pass that over. Next is Jermaine Armstrong. He's got an out-of-state hold, so I'm gonna find probable cause, and it's no bond. And I think that's all we probably need to do at this point. given that's an out-of-state hold. Anything else?
Nothing from the state.
No, that's it, Your Honor.
Okay, thank you. Next is Ami Bendir. That's a warrant for a misdemeanor with a $25 bond and loitering and soliciting for prostitution. She bonded out?
No, she's at North Broward.
She's in
North Broward,
Your Honor.
okay.
Also, this is a municipal ordinance, so my office cannot represent her. And so she's representing herself this morning. She is entitled to an attorney provided by the city, but they do not come on the weekends.
Okay. All right, ma'am, I can reset this if you want me to, so that you can have an attorney there on, will they have an attorney there on Monday?
That's up to the city in Hollywood. I know they won't be here on the weekend, I don't know.
Okay, well, I'm not gonna reset it then, there's no point in doing that. What do you wanna do today, ma'am? I'm gonna find there's probable cause, so, for the misdemeanor.
Can I finish it up today? Can I?
Yeah, I think so. I mean, you wanna, just plead to time served. What are the priors, State?
Sure.
It's gonna go on your record if you finish it up today, but, it'll also get you out of jail, so just be aware of
Okay.
that.
I'm here for something else anyways.
Okay, you have another case pending?
Yeah,
Same thing or something else? Something different?
something else.
All right. Is it gonna keep you in jail, the other thing?
Yes.
Okay. State, what does she have pending?
Tampering with
There's a
evidence?
tampering with evidence, Your Honor.
All right, what is that, a third-degree felony?
Yes.
Okay. Who's that in front of?
Judge Siegel,
And when are you scheduled for court?
July 27th?
You want me to just reset this to July 27th, and then you can try to take care of it all then, or you want to take care of it today for time served?
No, we can take care of it today.
It may affect your sentencing score sheet.
Well,
It may get you a point on your score sheet that'll put you in for a longer period of time on the sentencing. Isn't that right, State? I haven't done criminal in a while, but won't this?
Potentially it could.
Yeah, I'm not going to,
Okay.
I'm gonna reset this for, that same date as the
Okay.
other one in front of Judge Siegel.
Okay.
And that's on the 27th of, when did you say it was, July?
July,
yes, sir.
Can we not do
Yes,
that?
Your Honor.
Because this is a misdemeanor. It's gonna go before her judge before that.
Okay,
So, because they're gonna kick this back. Felony judges don't plea out these cases.
Okay.
They send them back to the misdemeanor.
all right, I would leave this pending until you can resolve the felony so it doesn't affect your
Okay.
score sheet. And/or talk to your lawyer about it before you resolve it, okay?
Okay, thank you,
So
Your
I'll
Honor.
leave it pending, you'll have a hearing in front of a county court judge. Talk to your lawyer about what you should do about this charge, okay?
Yes, Your Honor.
All right, I'm gonna find probable cause. What's that?
For the order.
Oh, that one goes this way, okay. I'm so used to throwing them the other way. Here you go.
Thank you.
Yeah. All right, next is Garcia, Yocasta Garcia. It's a trespass charge.
She's not on medical loan, Your Honor.
Medical, okay. So that'll get reset. All right, Altheria Jordan.
She's a medical reset.
Medical reset, okay. Next is Maria Pineda,
Main jail, Your Honor.
okay. Looks like she's got a couple of warrants for traffic. The bond is already set at $1,000 on those. And then she's got the new charge, which is a possession of cocaine. I'm gonna find that there's a probable cause for the new charge. And State, what can you tell me? What priors?
Just two 2018 DWLSs as far as pending, as far as Broward County is concerned. Your
Okay,
Honor.
so those are the two that are on here.
That's
where-
correct, Judge.
Okay.
Yeah.
All right, recommendations.
State would just seek the standard amount, $1,000 for count one, Judge.
Okay.
Your Honor, Miss Pineda cannot afford bond at all.
Okay, all right,
Your Honor, just so the court is aware, Ms. Pineda was a no-show. That's why she has a FTA. She had an FTA in May of this year and another FTA in.
so she's not a
June
good,
of
she
this
has,
year.
she's a high risk for, pretrial release.
Anyone you ordered to pretrial?
I know, but.
Your Honor, she'd
we're-
be amenable to an ankle monitor if the court was so inclined.
Is she at North Broward?
Maine, Your Honor.
Okay. She's amenable to what?
An ankle monitor, a level 2 ankle monitor, if the court is so inclined.
On the one that has a capias? But she didn't have an ankle monitor on it, I'm sure, when standard. Do you have a good address for her?
Yeah. What is the address?
What does she do for a living?
Right now, she's unemployed, Your Honor. She does have an address and a telephone number.
Okay, what is it?
13230 Southwest 9th Street, Davie, Florida. The telephone is 954-234-5203.
All right, and who resides there besides her?
She resides there alone.
Thank you.
Oh, with her kids.
Okay. And how many kids does she have?
4.
7-month-old.
A 7-month-old up to an 8-year-old.
Okay, and how does she survive without a job?
Well, I normally work. I just got
Where do she says she normally works. She just recently was laid off.
Okay, and where did you work?
Remix embroidery.
Where did you work?
Remix embroidery.
Remix embroidery. Is that in Davie?
No, it's in Oakland Park and Andrews.
In Oakland Park, Your Honor, in Andrews at the intersection.
All right, I'm gonna order a level 2 pretrial release with a monitor on the possession of cocaine charge, and
She has 2 cases on 2.
what kind of record did she have? I'm sorry, I didn't. Just the 2 traffic.
Just the 2 pending cases. But
Or,
the fact
yeah.
that she was already on pretrial release, she has 2 cases on 2 pending cases.
Well, the problem is somebody's got to take care of her 4 kids. That's really the problem.
Yeah, my kids.
Yeah, I mean, that's, we got 4 kids. I mean, next thing we'll be having a shelter hearing on the 4 kids,
That is true, Judge, but we also have to make sure she doesn't.
That's why I'm putting an ankle monitor on her. I don't think the money, somebody if they can post a $2,000 bond, if they could, I don't think that's a big deterrent. I think an ankle monitor is a bigger deterrent. So I'm gonna just order her on level 2 on all the counts. What's that? Just on. Can she make the bond on the 2 warrants?
No, Your Honor.
Can she make a $100 bond?
She does not know she would try to make a phone call for that, but there's no guarantee at all.
Who's the judge on the traffic? Who is it? Is she scheduled for? She was not scheduled for anything, right? What's that?
And we'd ask that you don't
I
modify
mean, she
it.
was scheduled, but she didn't show up.
So she had, what's the earliest we
I
can
mean,
get her
but as of
scheduled?
Right now, she's not scheduled because she was KPS.
Right, if I, ask how soon she can be rescheduled in front of Fishman, do we know?
Well, if she's in custody, because Fishman is a satellite judge, it is to be transferred here to a judge here, and she'll see a judge within a week.
But it'll be in the main courthouse, it won't be Fishman.
Right.
All right, so it's not gonna be Fishman anyway, all right. I'm gonna just ROR on the two, traffic offenses.
Just ROR, no pretrial.
No pretrial.
Okay.
Right?
Right, on the KPS.
Right.
Just on the direct, the new charge, correct?
Right.
Right, on the new charge, she's level 2, on the, KPSs, she's just ROR.
Okay, and then would you, no intoxicants, drugs,
Yes,
will you be asking for her to be randomly tested?
yes,
Okay, any drug evaluation?
yes,
Okay, and then will you be waiving the electronic monitoring fee?
yes.
Okay, thank you.
All right. All right. Jenna Paul, where is she?
No problem.
All right, possession of cocaine and drug paraphernalia. I'm gonna find probable cause, priors.
No priors in Florida, Judge. State's not seeking to increase the bond amount.
Okay, public defender.
Your Honor, I spoke to Ms. Perpall this morning. I just want to point out to the Honor, reading the probable cause affidavit, I don't know if this is a residue case or not, because the probable cause affidavit does not specify one way or the other. And I do know when it comes to residue cases, generally the state is filing those cases without actually charging the drug possession. And the officer doesn't allude to anything other than the pipes, and that something was tested. He doesn't say it was something loose. I will say for Ms. Perpall, she's lived in South Florida her whole life. She does have all her family down here. She does work at as a server at a Carrabba's restaurant. She lives with her parents. I do not believe she has a significant prior arrest record. She does not know if she can get family to help her with the bond or not. She cannot bond herself as of this moment on her own. Because of that, I would ask Your Honor if you consider some sort of non-monetary release.
Okay, and let me look at her risk assessment. She's a moderate risk. Enter. It says it's a 2.
Yes. That's a
Medium risk level. All right, and why is it a medium? Because of the drugs?
Your Honor, I was not the one that ran
Oh, okay.
this, but it's based on her stable residence,
Okay,
employment history, and then the current charge generally, Your Honor.
okay.
And any drug abuse history.
State, any priors? You said no?
No priors in Florida, Judge.
Okay, I'm gonna order her into pretrial release.
Standard?
Yeah, standard pretrial release.
On both counts?
Yes,
Any random testing,
yes,
evaluation?
all those. So you're gonna be drug tested to make sure you're off drugs while you're on pretrial release. You understand that?
Yes,
Okay. All right. Thank you.
thank you.
Mm-hmm. Angelic, Joy, Laughter.
Lauder, good morning, Your Honor.
All right. All right, so she's a low risk, number 3. They're writing
The
it
bar chart is right up front, and it says right in there, medium.
medium, okay, she's a medium, oh, it's a bar at the bottom, okay, great. All right, and her bond is set at $1,000 for grand theft, and I'm gonna find probable cause. Recommendations, priors.
State's not seeking a bond increase, however, we would like to inform the court that she does have 9 prior theft cases, Your Honor.
Okay,
Or convictions.
Public defender.
Most recent being in 2018.
okay,
Your Honor, I spoke to Ms. Lauder this morning. She's lived in South Florida for 20 years. She has her husband who she lives with. Currently, she has no income and she has no savings. She tells me she's going to be unable to afford any monetary bond. She does not believe her family can help her. I would ask Your Honor if you would consider some sort of non-monetary release, even with an electronic monitor. If Your Honor does want to use a monitor, I would ask for you to waive the fee as she cannot
Okay.
afford it.
State, any particular reason not to do a monitor versus $1,000 since she's poor and can't afford it? All right, I'm gonna
If the
do
court
a,
deems that's best, Judge. I mean, she does have 9 prior petty thefts. I mean,
That's not good. I agree with you, but,
I know.
you know, it's the kind of thing that, you know, I'm gonna order, level 2 with the drug testing and all that. Monitor,
And you're gonna waive the fee, Your Honor, please.
and I'll waive the fee,
Thank you, Your Honor.
yeah. What's that? Oh, here's a bunch of them, look at that.
This is the one you just ordered.
Is it? Let me see what you got over there.
Okay, who did we just?
That was Mr. Lauder.
Lauder, okay,
Okay, yeah.
thank you.
And this is the one from before. Yeah, just it flipped over when I threw it over there. Okay, is it Tammy Lewis? Tammy
Yes, sir.
Lewis, okay. Drug paraphernalia and possession of controlled substance without a prescription.
Just so Your Honor knows, I have no objection to probable cause, and if the state's not seeking an increase, I would just ask to leave it the same.
Okay,
State's not seeking an increase, Judge.
all right, then I'll just leave it the same and I'll
Did you
find.
find probable cause?
I am gonna find probable
Okay,
cause.
Ms. Lewis is currently on pretrial supervision in case number 18-6181 CF10A, possession of cocaine and drug paraphernalia. Pretrial would be asking that you revoke her supervision in that case.
Okay. She failed. Would be a fair assessment. She, okay. All right, so I revoked,
To the
oh,
right, Your Honor.
I'm sorry.
That's okay. Will you be holding her no bond, or would you be placing bonds on those charges?
She had, what'd she have, paraphernalia and,
It's a cocaine possession and a drug paraphernalia.
same thing she's got now, same charge.
Yes, Your Honor.
I'll set the same bond, $1,000 on that.
So 1,000 on the cocaine and an ROR on the drug paraphernalia.
Correct, correct.
Your Honor.
All right. Your ROR is revoked on the other one, and you have a $1,000 bond on that one as well, okay? Anything else? All right, Kristen Jackson.
No problem.
North Broward, okay, there's Miss Jackson. Neglect of a child without great bodily harm. And I read the probable cause affidavit, and it looks like there's probable cause. Any arguments about probable cause?
No argument, Your Honor.
Okay. Currently, there's no bond set on it?
Currently, it's set off.
And this is this a third-degree felony?
That is correct, Your Honor.
All right, and any priors?
No priors in the state of Florida.
Okay. And this was a 7-year-old, if I remember right?
Yes. No, he's talking about.
All right, I'm gonna just order pretrial release.
Your Honor, the state wouldn't object to that. The state would be seeking a $5,000 bond due to the facts of the case.
Well, I mean, when she confessed to the police officer, she said she left to go to the doctor because she was pregnant and was having medical issues. So,
But
I mean, I can't tell if that's true or not true.
the
but-
state would argue, though, that if that was the case, I mean, she could have brought her child with her. I mean, there are other factors.
Not only could she have, she should have brought her child with her.
Yes,
But again, you know, it's a mistake. She hasn't got any priors, and that'll be sorted out in the trial court when she goes there. So I'm just going to release her on her own recognizance under the supervision of pretrial. Standard pretrial, right? Do the drug testing though, because I do want to make sure that they're. Yeah, I do want to make sure there's. Yeah, an evaluation and drug testing. Yeah.
Thank you,
Okay. Okay. All right, I had a, what's this probable cause determination for Jamie Raquel Bradbury?
She's
What
a
is it?
medical research, Your Honor.
Reset, okay,
Yes.
there you go. All right, Victor Brown, is he in the main jail? Victor Brown,
Main jail, Victor Brown, President.
okay. He's got 4 warrants for traffic, so obviously there's probable cause.
Come on, stay in the same order. Same order.
Status is June 27th.
Okay, you'll be in front of your judge on June 27th. I'm gonna leave it a no bond, all right? You're gonna go in front of your judge on June 27th. Next is Lorenzo Brown. Driving while license suspended, possession of cannabis. I can't tell what happened with the possession of cannabis here. Not charged?
No, yeah, that was not charged, Your Honor.
Okay, so the only thing he's got is driving while license suspended, and it's a second offense, which always makes it hard to argue that they didn't know, the person didn't know their license was suspended. Okay, what kind of bond? Any priors? He's got a $100 bond as it's presently set.
Yes, Judge, she has a 2014 possession of cannabis, 1-year probation, 2011 resisting without violence, a DWS, a 2007 false name, 38 days prison, jail, and also 2007 possession of cannabis, another 2005, 2005 driving while habitualized adjudication. And
That's why he can't get a license, because he's habitualized?
where he violated probation, Judge. Yes, that's correct. And a 2001 theft adjudication.
Yeah. Is he, would he ever qualify like for a work permit, or is he just prohibited from any kind of driving for life?
I'm not for sure and really don't have control over what the DMV would
Yeah.
do in this case, so yeah, the state can comment on that.
You tried to get a work, has he tried to get a work permit?
Yes, Your Honor. I've hired an attorney to get my license back. But,
Okay.
I'm in the process.
Okay. There you go. All right, well, you can't afford a $100 bond?
Your Honor, he'd like to resolve his case today if the court would consider that.
Yes, Your Honor. I'm working. I have 2 small children. I can't afford any money right now.
Okay, so he wants to plead, what, no contest?
No contest. No contest.
All right. All right, and do you guys represent him for the plea, or is that something he does on his own? If he, in other words,
We could take care,
you are allowed to represent him?
Yes.
Okay,
Your
great.
Honor, would you consider RORing him? We just, after further discussion, he's working on his license and we don't wanna mess that up if we could, avoid it.
Yeah, the only problem with that is if he's driving in the meantime, you know, it's going to violate the conditions of his release, but, yeah, I'll, State, what's your position?
The state would ask that you keep the $100 bond in place.
Well, that'll keep him in jail forever, because he can't afford it.
Exactly.
I might as well set it at $100,000.
Exactly.
How about pretrial release? What are you all showing on him? Let me see here.
Pretrial release.
Okay. And his pretrial risk is medium. Any problem with pretrial release low level? Well, he's going to have transportation problems getting there.
He's agreeable to that, Your Honor, standard pretrial.
All right, standard pretrial. Yeah, just the driving. The other one, there's no charge. Yeah, ROR on that, or even if I need to do that, I mean, if they don't charge it, I don't even think I need to
We're
fine
gonna
them.
leave it at no charge.
No charge, yeah.
I mean, it's just that Right,
Okay.
it's just whether you want him under supervision for the possession.
No, I don't.
Well, it's the same case, so it doesn't.
Yeah, it doesn't really
It's one
matter.
case, so it doesn't matter. It's one case. So don't.
Yeah. Okay, I think these are just the risk assessments here. Did I give you all the orders you had
Yes.
needed? Okay, all right. Next is Santos Ramirez, main jail.
Sorry. Spanish interpreter, Your Honor.
Okay.
Interpreter's Passeñana.
I'm gonna find probable cause. Does he want to resolve it today, or does he want me to just put it over, or can he afford the bond? Those are all the questions. There's probable cause.
Hay un motivo fundado para detenerlo. Mi pregunta es, ¿quiere resolver el caso? I'm so sorry, Anna. Do you want to resolve the case?
Resolve it today, or can he afford a $100 bond?
¿Puede pagar una fianza de $100?
Your Honor, we'd be asking for ROR so as not to have any immigration consequences.
Okay.
El abogado defensor allá presente en la cárcel le pide al señor juez que por favor lo dejen en libertad a usted bajo su propia responsabilidad para no tener consecuencias con la migración.
Okay, any priors?
No priors, Judge.
Okay.
State wouldn't object.
All right, I'll release him on his own.
Would not object.
El señor fiscal dice que no hay antecedentes penales y que no protestaría en cuanto al pedido del abogado defensor allá en la cárcel.
Okay, I'm gonna release him on his own recognizance.
Lo dejo bajo libertad bajo su propia responsabilidad.
All right.
Gracias, señoría.
Okay, Diego Rocha or Roca?
Good morning, Your Honor. North Broward.
North Broward, okay, let's go to North Broward. There we are. All right, he has a trespass, failure to leave property. I think he was sleeping on somebody's property, if I remember right. And it looks to me like there's probable cause, and I guess the only issue is, what are we doing with this case?
Your Honor, I spoke to Mr. Roca this morning. He advises he cannot afford bond. He wants to resolve the case to time served this morning, if Your Honor is inclined.
All right, any objection from the
No
state?
objection.
All right. All right, Mr. Roca, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, tell me your full name.
Diego Ezekiel Roca.
Okay, and is the Public Defender's Office appointed and representing him, or?
Yes, Your Honor, and I
All
spoke
right.
to him this morning.
Okay. All right, I just want to make sure a couple things. Are you doing, you can put your hand down. Are you entering this plea of no contest freely and voluntarily?
Yes, Your Honor.
All right, and is this what you want to do?
Yes, Your Honor.
Nobody's forcing you to do it.
No, Your Honor.
Are you under the influence of any type of drugs or alcohol?
No, Your Honor.
Have you ever been treated for any mental illness?
No, Your Honor.
Are you under the influence of any medications?
No, Your Honor.
Okay. All right, you understand that if you're not a U.S. citizen, this could affect your immigration status,
Yes, Your Honor.
okay? All right. At this time, are you pleading no contest?
Yes, Your Honor.
Okay, I'm going to accept your no contest plea. I'm going to find that it's freely and voluntarily entered. You understand that you don't have to do this. If you wanted to, you could have a trial on this and present evidence, and the state would have to prove you guilty beyond all reasonable doubt, and you're waiving your right to a trial, your right to do the discovery, to have the right to have an attorney represent you through that entire process. You're waiving all those rights?
Yes.
Okay. All right, I'm going to find it's freely and voluntarily entered and that he's waived his right to a trial, and I'm going to sentence him to time served.
Thank you, Your Honor.
Okay. Pre-trial goes over here. Yeah. Does he have any priors, State?
No, Judge.
I'm going to withhold adjudication.
Okay, and are we gonna impose a split clause?
Oh, sorry, Judge. Wrong defendant. Sorry, Judge. Wrong defendant. He does. He has a 2017 petty theft, another 2017 felony petty theft probation.
All right, so he's already had adjudications in the past?
Yes, Judge. That's correct.
All right, I'm going to adjudicate him then.
Are
Okay.
you gonna impose court clause or you gonna
Waive court costs. All right, next is Stephen Greenhill. Where's he at? Maine? Okay. There's Mr. Greenhill. All right, he's got a DUI, speeding, improper stopping, texting while driving. So he's got 3 infractions and a DUI, and his bond is currently set at $500. State, any priors?
It was this defendant that has no priors. The state's not seeking a bond.
I can't hear you.
It was this defendant that has no priors.
No priors?
Yes, Judge.
Okay.
State's not seeking a bond increase.
He has no priors. His bond is currently set at $500. Can he make the $500 bond?
Yes, you can.
All right, I'll just leave it the way it is then. I'm gonna find
Thank you.
probable cause.
Yeah, that's it.
All right, next is Ryan Poirier, and where's he located?
Main jail, Your Honor.
Okay, and it looks like it's a traffic capias with a $500 previously set bond. And since it's a capias, I don't need to make any finding of probable cause. And he failed to appear. What's the underlying charge?
Your Honor, he'd
He's
be,
a no valid judge.
No valid driver's license?
Yes, Judge.
First offense?
He had a 2014 no valid.
Okay. Well, let me just add, does he want to try to resolve it?
yes, Your Honor.
All right.
He would like to.
All right, Mr. Poirier, what are you gonna do about trying to get your license situation straightened out?
I'd have to pay off some fines first, and then I'll be able to get it back.
All right. All right, well, every time you drive, it gets worse and worse, you know, it makes it harder to, to get your, license back. So, all right, so you want to enter a plea of no contest at this time?
Yes, sir.
All right, let me get you to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Tell me your full name.
Ryan Dean Poirier.
All right, and do you understand that you don't have to do this, that if you wanted to, you could have a trial on this issue? You could do discovery and have a lawyer represent you for a trial, and you're waiving those rights?
Yes, sir.
Okay. Have you ever been treated for any kind of mental illness?
No, sir.
All right. Are you under the influence of any drugs or alcohol at this time?
No, sir.
Okay. You understand if you're not a citizen that this could affect your immigration status?
Yes, sir.
All right. Understanding all that, do you want to plead no contest?
Yes, sir.
All right. And you need to say no contest so I can hear it.
No contest.
All right. I'm going to accept your no contest plea, and I'm going to, is this something I can withhold adjudication on? State?
Yes, Judge.
I'll withhold adjudication on the charge and just take notice of the time you spent in jail, okay? So it's a withheld adjudication, waiver of court costs.
Oh, good.
All right. Here's there's his order. All right. Next is Gregory Morris. Where's he? Is he in the main jail?
Main jail.
All right, Gregory Morris.
Sorry, I beg your pardon, Your Honor, bonded.
He bonded out, all right. I'm gonna find probable cause. Next is Michael Sutton.
I'm sorry, what happened with Morris?
He bonded out.
You bonded, thank you.
Yeah. All right, Michael Sutton has a DUI and a criminal mischief which was not charged. And I'm gonna find probable cause as to the DUI. And can he make the bond?
Yes, you can, Your Honor.
All right. I'm just gonna leave it the way it is and find probable cause, all right?
Your Honor, we would be requesting a photo order, that's all, as well.
Okay, I'll
Just
do
a
a
photo order.
All right, on Michael Sutton, I'll do a photo order as well. Okay. Trent Shirley, it's 2 capiases for misdemeanors. So obviously there's probable cause.
I believe it's a medical reset unless someone says he's somewhere in one of those jails.
Okay, it's a medical reset. There's that one. All right, let's see. Next is Ronald Robillard.
Conti, Your Honor.
Okay, switching over to Conti, and looks to me like there's probable cause. Any arguments on probable cause?
No, Your Honor.
All right, so I'm gonna find probable cause, and looks like he has no bond at this time. Public defender, is he entitled to a bond?
Yes, Your Honor, he is entitled on this charge. What I'll let Your Honor know, this is actually count 2. There is a count 1 that was a similar charge. On that charge, he was ordered, I believe he came through 3 days ago, and he's being held on $5,000 bond in custody. If he bonds on that case, he is going to go on pretrial with an electronic monitor. He is not bonded on that case. He's unable to afford the $5,000 on that case. To be honest with Your Honor, given that situation that he can't bond out on the other case, I would ask for a nominal bond to be placed on this, and then I have no problem if that's followed by the electronic monitor since he's going to have an EM. Based on the other case, the only thing I would ask if we could waive the fee.
Okay, state, what's your position?
Your Honor,
There's
this-
probable cause.
Yeah, the state would be requesting a $10,000 bond on this case. It is charged as a robbery with a weapon.
There was a threat of a weapon.
Yes, there was a threat of a weapon. It was actually the defendant himself who told the victim he had a gun in his backpack. The probable cause does not state that he did brandish or show the gun, but the defendant himself stating he had a gun. And furthermore, his priors.
Yeah.
Yeah, in... He has a 2016 battery. He has a 2009 robbery, no weapon, and a battery. He was sentenced to 2 years and labeled as a habitualized offender. In 2006, carrying a concealed firearm. He was sentenced to 2 years. In 2006, 2 counts of burglary and 1 count of resisting without violence. He was sentenced to 18 months probation on count 1, count 2, 12 months on count 3. In 2005, carrying a weapon openly, he was sentenced to 32 days.
Okay, I'm gonna find probable cause, as I said before. I'm gonna set his bond at $5,000 with electronic monitoring, if he is released. Yes. Right, all those things. The usual list.
And what level is that, Your Honor?
That's a level 2. Okay? So if the other charge goes away or whatever, he'll still have this that he has to comply
And Your Honor,
with.
we'd also ask for no victim contact. And
No victim, I've already ordered it.
Okay,
Okay,
thank you.
all the standard stuff. But it's a good thing you put that on the record, which is good. Stanley Anam. Stanley Anam. Where's he? Is he at Conte? Maine, okay.
Maine jail.
All right. All right. Any arguments as to probable cause? All right, I'm gonna find probable cause. And can he forward the bonds as they exist?
Yes, Your Honor.
All right. State, what's that? Yes, sir.
How much is your?
All right, I'm just gonna leave it the way it is.
One moment, because how many counts? I'm showing 11 counts.
I'm showing 8
There's a
on,
second page.
all right.
Because there's count 10 and 11, there's no bond. And he has
Yeah.
a status before his judge on the 29th.
Okay, I'm gonna leave it the way it is.
You need to set bond on count 6 and 7.
Count 6 is the fleeing and eluding a police officer at a high speed, and 6 and 7. All right. What's the standard bond on that? $1,000? $500? $10,000? Who knows? What is it, state? What do you all recommend?
We recommend 3,500 on each judge.
Okay. I'm gonna set the bond on each of them at, 1,500 each. 1,500 on count 6 and 1,500 on count 7.
You can still make bond, Your Honor.
Okay. I can't find a second page. Yeah, I don't see it on there.
Right there.
Oh, there it is, okay. Let me look at the second page of this. Taillights, oh, he's got a capias, felony capias, and a warrant for VOP. So those two, the 10 and 11 have no bond, but he can deal with that when he goes in front of the judge. You see that on the second
Yeah.
page? Yeah.
I already know.
All right, so he'll have to deal with that with the judge, his regular
Very good.
judge. All right,
Yeah, understood.
all right, thank you. Next is Michael Retog, RETNG or OG? It's main jail?
Main jail, Your Honor.
All right, any arguments on probable cause? I'm gonna find probable cause. Looks like he has a petty theft, which is no charge. A burglary of an unoccupied structure, which is what, a third-degree felony?
That's correct, Judge.
And then he's got a probation violation or community control, which is gonna be no bond, and out of county hold. So I'm gonna find probable cause. I'm gonna set the bond on the burglary at $5,000. And the petty theft is a no charge, so, and he's got no bond holds. All right,
Thank you, Your Honor.
Timothy Hall. He's got a premeditated murder charge, premeditated first-degree murder charge.
Yes, in your honor, the state is asking the court to make a proof evident presumption grade determination for count 1 and count 2. Both count 1 and count 2 are punishable by life. And the state is requesting a no bond hold on each of those counts.
Yeah, I mean, but I know that I usually would put a no bond hold on those until he can have an Arthur hearing. But usually that occurs in the division, not here in magistrate court. What's a public defender's position on that?
For someone to control the case law that.
I can't hear you. Speak up.
The case law that's applicable is Jusaza v. State. It's 222 Southern 3rd 3. It's a 4th DCA case. The 4th DCA is clear. For someone to be held no bond at magistrate, it works one of two ways. Either the state can make a filing for pretrial detention, which they have not done here. The other way is the magistrate judge, makes a finding, as the state's asking for proof evident presumption grade at the state's request. As we know, under the 4th DCA, proof evident presumption grade actually goes beyond a reasonable doubt. The concern here is that Your Honor says the charge is premeditated murder. There's no murder.
It's an attempted murder.
Your Honor said premeditated murder. So
Yeah.
I would ask the state to be clear on what they're asking for. I would ask Your Honor to be clear on what the actual charges are and what Your Honor is finding the
Yeah,
charge to be.
I have the warrant here, and the actual charge is attempted murder in the first degree, count 1, attempted murder in the first degree, count 2, shooting into an occupied dwelling, count 3, and those are the charges that are there. The bond is set at $10,000 on count 3, and count 1 and 2 are no bond. An attempted murder in the first degree is a, what is that, a life felony? Or first degree, first degree punishable by life?
Yeah, it's a first degree murder with a firearm or a deadly weapon. Here was a firearm.
So first degree punishable by life, he is entitled to a bond, correct?
No, it's a punishable by life. So the state again is requesting Your Honor to.
What I would say, Your Honor, it's within Your Honor's discretion. Your Honor can put a bond on this case, but I would say, reading the probable cause affidavit, that what the state's asking Your Honor to find proof and presumption grade, that actually goes beyond a reasonable doubt. Reading this probable cause affidavit, no one was actually hit with a bullet. This took place in a stairwell, which is a rather confined area. There is good argument to be made, it will be decided at trial, for this to potentially be an aggravated assault with a deadly weapon, which would be a bondable offense. That's not a first degree felony. What I would say today, that the state's asking Your Honor to find proof evident presumption great. We have no live testimony. We have no live witnesses before us. We do have the probable cause affidavit, but upon reading the probable cause affidavit, I do believe there is a good faith argument to be made that this is an aggravated assault with a deadly weapon. Obviously, that will be decided by the filers, that will be decided at trial. But because there is a good argument to make in good faith, I would say that precludes the state from meeting their burden of proof evident presumption great today, and I would tell Your Honor to set bond, monetary bond on count 1 and count 2.
Your Honor, the state would object to that. The defendant did use a firearm. He fired it at both victims. And again, we'd ask you to make a determination.
And indicated ahead of time he was going to, according to the statements that are in this affidavit. What's a record? Let me hear about the prior record, if any.
In 2009, he has a burglary of an unoccupied structure. He's sentenced to 18 months probation. And give us just a minute, Your Honor.
Sure.
There's a 2007 battery, 2008 possession of cannabis. There's a 2009 burglary of an unoccupied dwelling, domestic violence, disorderly conduct adjudication in 2009. Another a 2015 petty theft adjudication. 2017 possession of cannabis. And then there's a pending petty theft.
Okay. I'm going to set the bond on count 1 at $100,000 and on count 2 at $100,000.
Yes, and again, Your Honor, the state would object. The state is still requesting a no bond hold. I mean, count 1 and count 2 are both punishable by life. He did use a firearm. It even states that in the probable cause that they had a friend that was canvassing the parking lot. They used the gun, fired it at both victims. So again, the state would object to that and ask Your Honor to make a finding of proof evident presumption great, and the state would request a no bond hold on count 1 and count 2.
All right, well, I'm going to set the bond at $100,000 on each one of them. Okay,
Thank you, Judge.
Pre-trial release, do you guys monitor that type of crime, or is, I'm gonna order, what's level 1?
It's complete house arrest. We will only be able to leave the house to attend court, any pre-approved doctor's appointments, or if he has an emergency.
I'll order level 1. Okay.
One on all 3 counts?
On count 1 and count 2.
It's all, looks like it's all part of the same warrant, so
Yeah.
it's gonna be supervised under all of them.
Okay, all right,
Your Honor, I just want to clarify, you said 100,000 on count 1 and 100,000 on count 2?
correct.
Okay, and then the level 1 GPS and no victim contact, no
Correct.
return to the place. Thank you.
Oh, no return?
No, yep, no return.
Judge, you say you find PC.
But that was the victim's residence, right? That this happened at, it was at the victim's residence?
Yes, that is correct.
Okay, all right, so no return.
And Judge, you find PC for attempt?
Yeah.
Attempt, okay.
Yeah. All right, the next one is Anthony Tanhill. Anthony Vincent Tanhill. He's got warrants out So he's got a violation of probation, he's got a capias, those will stay the same. He's got a probation or community control violation. And then he's got a new charge of possession of cocaine, which has a $1,000 bond, and a possession of cannabis that's not charged. So I'm gonna find probable cause for the possession of cocaine, and I'm gonna leave it the way it is. So there's probable cause. He'll go in front of his judge to resolve it, all right? Yep. Next is, he's scheduled June 27th to go in front of his judge. Ty Christopher Pierce. Aggravated assault with a deadly weapon without intent to kill, and driving while license suspended habitual. All right. There's no bond currently set on the aggravated assault with a deadly weapon without intent to kill, correct? State, what's your recommendation for the bond?
As for count one, Your Honor, they would be seeking $3,500 bond.
Okay.
As for count two, we'd ask that it stays in place. As far as the defendant's priors, there's a 2016 resisting without violence and another 2016 battery. 6 months probation.
Okay. And the allegation here is it's a road rage incident. Any arguments as to probable cause? All right, I'm gonna find probable cause.
What was the recommended bond amount, Your Honor?
$3,500.
Count one.
3,500.
Okay.
All right, I'm gonna set the bond at $3,500 on count one. And I'm just gonna leave it at that. Okay, no victim contact as well. George Allen Kane. Looks like a possession of cocaine charge. And loitering for the purpose of prostitution, which was not charged, so. State recommendation?
1 second, Judge. Let me check the file. State's not seeking a bond increase, Your Honor.
Okay, defense? I'm gonna find probable cause.
Defendant can make bond, Your Honor.
Okay, I'll just leave it the way it is then. And I'm gonna find probable cause. Next is Irvin Bote. Grand theft. Bond is currently set at $1,000.
State's not seeking a bond increase, Your Honor.
Okay, defense? Defense? Thank you. Can you make that bond?
No, Your Honor. We'd be requesting that he be released ROR.
Priors?
No priors, Judge.
No priors, okay. Stable place to live?
Yes, Your Honor.
Okay, and can we have an address?
2540? 2440? DeSoto Drive. Miramar, Florida. 33023.
Okay, is that a house or an apartment?
It's a house.
Your house or somebody else's house?
My grandmother's.
Okay, so you're living, and what's your grandmother's name?
Lindy Buffon.
And it's okay for her, she allows you to stay there with her consent?
Yes.
Okay. All right, I'm gonna find probable cause. I'm gonna order regular level, standard pretrial. And there's probable cause. Okay. All right, next is Luis Rosales Ayala.
North Broward, John, he's gonna require a Spanish interpreter, please.
Okay,
Spanish interpreter present, Your Honor.
all right. He's got a DUI
Señor, lo acusan de estar conduciendo bajo los efectos
and possession of cocaine.
y de tenencia de cocaína.
His bond is currently set at 500 on count 1, DUI,
La fianza que le han impuesto en este momento es de $500 para la primera acusación de
Count-
DUI.
count 2, DUI with a blood alcohol level under .15, $1,000.
I'm so sorry, Your Honor, did Your Honor say under .15?
Yeah.
La segunda acusación es de DUI, según las siglas en el inglés, que tener el contenido del alcohol en la sangre de menos de .15 y la fianza es de $1,000.
And possession of cocaine, $1,000.
Y la fianza que tiene en este momento para la acusación de posesión de cocaína es $1,000.
All right, and it looks to me like there's probable cause. Any arguments as to probable cause?
No argument to probable cause, Your Honor, and I've been unable to speak to him since I do not speak Spanish. Can I just inquire, can he afford any monetary bond?
Pregunta el señor juez, ¿hay algún, parece ser que yo encuentro motivo fundado para detenerlo, algún argumento en cuanto a los abogados en cuanto a motivo fundado? El señor abogado defensor aquí presente le dice al señor juez que debido a que no habla el español, no ha podido comunicarse con usted y quisiera preguntar si usted puede pagar algún tipo de fianza monetaria.
Yes.
Mr. Ayala,
Señora Ayala,
can you afford monetary bond?
¿puede pagar una fianza monetaria?
He's asking,
Señor,
¿puedes pagar? Sí. Sí.
No, we're in
Yes.
North Broward.
We're in North Broward, so the other people need to be quiet or turn off their microphone.
Momento, señor. Señor Rosales, right?
Oh,
Señor
Rosales
Rosales,
Ayala.
¿puede usted pagar una fianza?
Sí.
Yes.
Okay.
How much?
¿Cuánto puede pagar para salir en libertad?
Can you afford the bond that the judge just set?
Señor, ¿usted puede pagar la fianza como la ha impuesto el señor juez en este momento?
Total is
Ahora no tengo el dinero conmigo.
Right now I don't have the money with me.
Yeah, the total bond is $2,500.
El monto total de la fianza para salir en libertad es de $2,500.
Can you call somebody?
¿Puede llamar a alguien?
Voy a llamar a mi esposa.
I am going to call my wife.
Okay, any priors, state?
No priors, Judge.
¿Algún antecedente? No hay antecedentes, dice la fiscalía.
All right, I'm going to set the bond on count 1 at, which is the first DUI charge at 500. I'm going to ROR him on count 2. I'm going to set the bond on count 3 at 500 on the possession of cocaine, so his total bond will be $1,000.
Voy a imponer una fianza para la primera acusación, que es el primer DUI, de $500 de fianza. Para la segunda acusación lo voy a dejar en libertad por su propia responsabilidad. Y para la tercera acusación, la posesión de cocaína, le impongo una fianza de $500 para un total de $1,000. I'm sorry, Your Honor, did you say 1,000?
That's right.
$1,000, sí, señor.
Yeah. All right, and there's probable cause.
Y hallo motivo fundado para detenerlo.
Okay, thank you.
Gracias.
Jorge Hernandez.
Main jail.
Okay, back to the main jail.
Spanish interpreter.
Interpreter present, Your Honor.
All right, Mr. Hernandez has a charge of unlawfully conveying fuel.
Señor Hernández, tienen una acusación en contra suya de transportar ilícitamente combustible.
And then a couple of tickets for an unsecured tag, which are civil infractions.
Y un par de infracciones en cuanto a que no tenía la placa de registro asegurada y son infracciones civiles y de tener una o tenerla no tenerla asegurada o oscura, perdón.
All right. And basically, when the police officer pulled him over, said that he had some stolen fuel, and his truck had an extra bladder drum.
I'm so sorry, Your Honor, extra bladder.
Bladder drum, full of fuel.
El señor juez está leyendo. Básicamente, cuando la policía lo paró, dijeron que usted tenía tenía combustible que había sido robado. Y, Your Honor, the interpreter is not able to come up with the word bladder. May the interpreter
Tanque de gasolina.
un tanque, yes, Your Honor. Que tenía un tanque lleno de gasolina.
Okay. All right, I'm gonna find there's probable cause.
Hay un motivo fundado para detenerlo.
And his bond is currently set at $1,000.
La fianza que le han impuesto en la actualidad es de $1,000.
Can he afford that?
¿Puede pagar esa fianza?
He can afford $1,000 bond, Your Honor.
Okay, I'll leave it the way it is then.
Sí, dice el señor abogado defensor de la presente que usted puede pagar una fianza de $1,000. La dejo así como está impuesta.
Okay, next is, well, this is a tough one. Oquendo, Necrosome Oquendo,
Yeah,
main jail, okay.
main jail right here.
Driving while license suspended, third or subsequent offense. Bond is currently set at $750. I'm gonna find probable cause. What about the bond? $750.
Your Honor, he could afford a $200 bond here. He has a job. He says he can actually get his driver's license back in 30 days. But for him to bond out, the bond can't be greater than $200.
Okay, and state, what about priors?
Of 2011 possession of cannabis. Also a DWS. Third subsequent one, adjudication withheld. Another 2009 DWS. A 2009 possession of cocaine, adjudication. 2003 possession of cocaine. Another 2003 possession of cocaine. Resisting officer without violence, adjudication, 1999. And that's it as far as priors are concerned, Your Honor.
All right, I'm going to set his bond at $200, but I'm going to order a pretrial release as well. Standard pretrial release. Count three. It's count three. Yeah, just count three. That's the only one that's a criminal offense.
Okay, Your Honor.
All right. And there's probable cause if I haven't already said that. Kamal Powell. Where's Mr. Powell? Main jail? Yep, there he is, okay. Carrying a concealed firearm, possession of cannabis, 20 grams or less, and possession of alprazolam. And he's got a bond of $1,000 on count one, $100 on count two, and $1,000 on count three. Any arguments on probable cause?
No, Your Honor.
I'm gonna find probable cause. What about his bond?
State's not seeking an increase, Your Honor.
Okay, let me ask the defense, what about his bond?
He can make bond, Your Honor.
Okay, I'll leave it the way it is then. And you said what are his priors?
It was a 2007 petty theft, 2016 petty theft.
All right, I'm not gonna order a pretrial on that. He's fine the way it is. Okay, Ellie Clermontville. All right, any arguments on probable cause?
For this one, yes, Your Honor, when it's count two, the possession with intent to sell or deliver within 1,000 feet.
Okay.
I really don't see either part of that charge. I don't see the intent to sell. I also don't see 1,000 feet within what. The probable cause affidavit silent to that, so I'd object to count two as is. I would not object if Your Honor finds probable cause to possession of cocaine, but not the first degree felony that's currently enumerated. I do not have objection to the other counts.
State, what's your position on probable cause? I don't see that, I don't see any kind of relation to any specific, like a school or a park or any of the areas that are protected by that 1,000-foot.
It is, did take place in a park.
Okay, where does it say that? Does it say that up at the, where it says the
in the very
event?
first sentence that, yeah, it says that the,
Weaver Park,
yes, that is
okay,
correct. It says he was driving recklessly through the park.
right.
So that's the location.
All right, so the 1,000 feet is met, and then a search of the vehicle showed marijuana, but was it any of it tested? Does it show it was tested?
There's 1 gram of marijuana and 11 grams of crack cocaine.
Well, that's what it says,
Yeah,
but
which-
usually
It says
on-
which both field tested positive.
Okay. All right, so I'm gonna find probable cause for count 1, count 2, count 3, count 4, count 5. Okay, so those are the only ones the other ones are infractions. And his current bond is set at $7,500 on count 2, and what, zero, no bond on the resisting an officer?
That is correct, and Your Honor, on count 1, the state would be seeking a $10,000 bond due to the facts of the case.
Right.
And on count 2, the state is not seeking to modify that bond. On count 3, we would be asking for a $2,500 bond.
Resisting with violence is a third-degree felony?
That is correct.
Okay. And obstructing, what is count 4? Is that a misdemeanor,
Yeah,
second
and
degree?
count 4, we had also asked for a $2,500.
Is that a misdemeanor?
No, that is a third-degree felony.
Okay. And public defender, go ahead and tell me I'm gonna find probable cause, but tell me your position on this.
Your Honor, what was the recommendation with respect to count 1? I couldn't hear it.
7,500, or 10,000?
$10,000.
10,000. All right, so here we.
Is that a third-degree felony?
Yes, that is correct.
Okay.
All right, Your Honor, he thinks he can make bond at 1,000. I mean, on 10%. So the total we're looking at is roughly 10,000.
All right, I'm gonna set the bond on count 1 at 7,500. The bond at count 2 will stay at 7,500. The bond on count 3 is gonna be 2,500, and the bond on count 4 is gonna be 2,500.
It'd be like 20 grand, so it'd be like two grand.
5, 6, and 7. Did you need?
And you said there weren't, did you say there weren't any priors, or there were minimal priors?
No priors from the state of Florida.
No priors in the state of Florida. Yeah, I'll just leave it that way.
Wait. Your Honor, if I could just talk to my client for a second.
Sure.
further.
What was your
You
question?
got 5, 6, and 7. Know where it is?
Yeah, I'm gonna leave the rest of those at 25. I didn't realize those were, I thought those were infractions. What those infractions?
Your Honor, the defendant doesn't think he can make more, he can come up with more than 10,000.
Well, tell me a little bit about him.
Sure. Let's.
Good things.
He's lived in Pompano his whole life, Your Honor.
And he has no priors. What does he have?
For an ODL in Palm Beach.
Okay, no driver's license, all right, in Palm Beach.
His mother and father live here.
What's he do for a living? How old is he?
He's 18 years old, Your Honor.
Is he in school? What's he doing?
Yeah, school in the summer. I was going to Dave Thomas. I was just about to sign up.
He was signing up for Dave Thomas School, he says, for this summer. Have you signed up for this?
Yeah, to bring on my credits, yeah. My sister, I was about to sign up and like, I don't really know. I just know my sister told me she was going to sign me up.
Well, you know, his parents can bond him out. I mean, they can, if he's got property, he's lived in Pompano, they can go and put up collateral for him. So I'm gonna leave the bond the way it is. And I'm gonna also order level standard pretrial release.
Your Honor, if we could request no return to the location of the incident.
Yeah, and don't go back to that park, Walker Park. Where is that? What is it?
It's right by my house.
Oh, it's by his house, okay.
800 Northwest 20th Street, Pompano Beach, Florida 33060.
And your house is at 660 Northwest 21st Street, so he's about, what, 2 blocks away?
Mm-hmm.
Okay, so go around, come to your house in a different way, don't go to that park, okay? Because you don't
Yes,
want to
sir.
run into that police officer again, and he doesn't want to run into you, I'm sure, okay?
Yes, sir.
All right. Here's the, I'm gonna leave the infractions at 25 each. I don't know why those are criminal offenses?
Yes, they are. They're
Okay.
misdemeanor charges, I believe.
Okay.
Those are second-degree misdemeanors, Your Honor.
Yep. Okay, I'll leave those the way they are. Next is Matthias Rodriguez. All right, where's Matthias? Is he at the North Satellite or what's his? Maine, okay. Matthias Rodriguez at the Maine Courthouse.
Bonded, Your Honor.
He bonded out, all right? Find probable cause. On the ones that are bonded, I don't need to find probable cause, or do I? It doesn't matter?
I still need you to sign it.
Okay. All right, here. Okay. Yeah. It has no practical effect, but there's probable cause. All right, there's that one, great. Okay, Alvin Williams is next. Let me find Mr. Williams's information here. All right, I've got Mr. Williams here, okay. Purchase of cannabis, $1,000 bond, and let me just review this again. All right, so he bought $20 worth of cannabis according to the PC sheet, and I'm gonna find probable cause. So what's his, what are his priors?
Priors, Judge. Not object to whatever the court deems necessary.
What does the public defender want?
I'm I couldn't hear, but there are no priors, is that right?
No priors, and the state said it's up to me, so what do you want?
Mr. Williams says that he can make bond.
Okay, well, I'm gonna release him on his own recognizance.
Very good. Thank you, Your Honor.
Mm-hmm. Yeah. Christian Peterson. Is he in the main jail? Peterson.
He bonded, Your Honor.
All right, he bonded. There you go. Next is Rodney Holloman. And he's got possession of a weapon or ammo by a convicted felon, carrying a concealed firearm, and grand theft of a firearm. All right, I'm going to find any argument on probable cause? All right, I'm going to find probable cause. And he's got $1,000 bond on count 2 and $1,000 bond on count 3, and currently no bond on count 1.
The state is requesting a $7,500 bond on count 1.
And priors?
Yes, he does have priors. He has a 2014 resisting without violence, a 2014 fleeing and eluding, which is also a violation of probation. He was sentenced to 30 months. He also has a resisting without violence in 2014. He has a possession of cocaine in 2014. There was a violation of probation. He was sentenced to 30 months. Possession of controlled substance. He also has in 2014 tampering with evidence, which was a violation of probation. He has in 2013 possession of cocaine and possession of methamphetamine and a resisting without violence that he was sentenced to 30 months. 2013 loitering and prowling. 2012 possession of cannabis, possession of drug paraphernalia and reckless driving. It was also a violation of probation. He has a 2011 possession of cannabis, a 2010 possession of cannabis, and a 2009 possession of cannabis.
You know, looking at the probable cause affidavit, the only thing I have a question about is the count that says that he was carrying a concealed firearm. I don't see that the firearm was concealed on the probable cause affidavit. I see that he is alleged to have taken it out of a vehicle and thrown it over a fence, but I don't see anywhere in here that the probable cause affidavit says that at any time before that it was concealed. Could have been sitting on top of the passenger seat where it would not have been concealed. There's no explanation as to why there's a concealed.
Well, Your Honor, it says that he was observed by the law enforcement officer, that he was observed ducking behind a vehicle. I don't see where he was in a vehicle.
I was ducking behind a vehicle, but I mean, it doesn't say the gun was concealed from sight. So I don't think there is probable cause for count 2. I am going to find probable cause for count 1 and count 3. On count 2, there's no probable cause, so he's ROR'd. On count 1, what's the state's recommendation on his bond on that?
Okay, yeah, Your Honor, on count 2, I mean, the state would object to that. I mean, he was in possession of a firearm. The officer, when he first observed the defendant, he didn't see the firearm.
That's because he ducked behind a vehicle. He doesn't know whether he was carrying it in his hand, in his pants, or his waist. So you can object. It's on the record, and I'm going to find there's no probable cause for count 2. What's your recommendation as to count 1 for the bond?
On count 1 would be $7,500.
Okay. All right, that's a reasonable request. $7,500 bond on count 1.
Your Honor, the defendant can afford a maximum of $300, he tells me, to bond out.
Okay. Well, the bond's still going to be $7,500 on count 1. Count 2 will be ROR because there's no probable cause. And count 3, the bond will stay the same at $1,000 for a total bond of $8,500. And there's that. Thank you.
Thank you, Your Honor.
Felix de Martinez Hernandez. Not a good candidate for
Bonded,
preacher.
Your Honor.
Yeah. He bonded, and I'm sure we'll see him again. I see he's a high risk. Oh, okay. All right, I'm gonna find probable cause. There's that one. Next is Randy Bergen Jarvis. And he's got, let's see, possession of ecstasy, resisting an officer, obstructing without violence, tampering with or fabricating, tampering with evidence, I guess is what it is, $1,000 bond, petty theft, and possession of cannabis, no charge, resisting an officer, obstructing without violence, not charged. So his current bond is $1,000, $100, $1,000, and $750, which is $2,850. And any arguments as to probable cause? All right, I'm going to find probable cause. What's the situation as far as priors?
1 second, Judge. We're looking. 17, 7, 4. All right, there's a 2013 burglary of a conveyance and a petty theft adjudication. There's a uttering a forged check adjudication. Along with the wear and tear adjudication. Uttering a forged check adjudication. Possession of cocaine 2016 adjudication. Possession of cocaine and cocaine another 2016 adjudication. Also a pending case.
Okay, what's the pending
Broward.
case?
It's a resisting officer with violence. And a bat Leo, Your Honor.
Okay.
That case is pending in front of the judge.
All right, so what's your recommendation on the bond?
As for count 1, Your Honor, state seeking a $2,500 bond. As for count 2, state seeking a $500 bond. And as for count 3, state would ask that it remains in place at $1,000, Your Honor.
Count 4, petty theft.
And 4, remain in place, Your Honor.
Okay, defense?
All right, defendant can make bond, Your Honor.
With a $5,000 bond on count 1, which is what the state's recommending?
Oh, I thought they said 2,500.
That's the
They said
case at
2,500?
Yes, Judge.
All right, I'll set the bond on count 1 at 2,500. The bond on count 2 at 500. The count on count 3, I'm gonna reduce that to 500. And, the petty theft to 500. So, count 3 and 4 will be 500. The resisting the officer will be 500. And count 1 will be 2,500. Everybody got that?
Yeah, what's it, 4,000?
4,000 total.
Yes, Your Honor, thank you.
Okay. Okay, next is Roland Moriera Valdez.
Bonded, Your Honor.
You bonded, okay. He's bonded, this one that's coming your way. He's bonded, okay. Next is Lazaro Almaguer.
He also bonded, Your Honor.
Okay, he's bonded, so that one's going your way. Ronnie Sip, possession of cocaine, his bond is set at $1,000. Is that Mr. Sip?
Yes, at Maine, Your Honor.
All right, state any priors?
Yeah.
Yes, Your Honor. He has a 2013 aggravated fleeing and eluding that involved injury. That he was sentenced to 54.9 months. Yeah, state prison. Also in that, it was leaving the scene of an accident with injury, a reckless driving with personal injury, and driving while license suspended. In 2012, possession of cocaine, which was also a violation of probation. He was sentenced to 54.9 months of state prison. 2011, possession of cocaine, violation of probation, 54.9 months in prison. 2011, delivery of a controlled substance, violation of probation, 54.9 months. 2011, possession of cocaine, possession of cannabis, possession of drug paraphernalia, 54.9 months. 2006, possession of cocaine with the intent to distribute, 24.6 months. 2005, possession of cocaine, was sentenced to 1 year, 1 day in prison. 2004, resisting without violence. 2003, possession of cocaine, violation of probation, sentenced to 15 months in prison. 2003, possession of cocaine, violation of probation, resisting without violence, 15 months in prison. He also has a 2000 resisting without violence, and in 96 he has a burglary of a dwelling. He was sentenced to 72 months, and in 96 also a robbery without a weapon, and he was sentenced to 72 months.
All right, so he's got some, what I would call violent type priors way back in the 90s, and he still has a drug problem, according to the drug history anyway. So, State, what's your recommendation? All right, defense, what's your recommendation?
Your Honor, the defendant cannot afford any bond. We would be requesting either ROR or pretrial release of some sort.
Okay, I have an address on the probable cause affidavit of 209 Northwest 15th Court, Pompano Beach, Florida, 33060. Is that your address, sir?
Yes, sir.
Is it an apartment or a house?
It's a house, sir.
And who do you live with there?
My mother, Helen Silk, and my father, Henry Silk.
All right, so they let you stay there.
Yes, sir.
Okay.
But I've been working since I've been out.
Where do you work?
I was working at a tire shop, helping them out on Dixie and 15th Street, like next street over from my house.
Okay.
And they'll let me help them out with the tires and stuff.
All right, I'm going to put him on pretrial release at this time, and it'll be just the standard pretrial release. But I do want, I almost hate to do it, but drug evaluation and random testing. Yeah, no intoxicants. So you got to stay clean and sober. And I know that's going to be tough given that history, but you got to do it. All right, next is Christopher Edward Logan.
Should be North Brown.
North Brown.
Your Honor.
Yes.
With respect to Ronnie Sipp, might it be possible to waive the cost of drug testing?
Yes, I will.
Thank you.
Hold on, what? Okay. Because of why? Okay. Yeah, I don't know if counsel, on that last, I can't waive it without him filling out some forms, and he's got to fill out some forms on the drug testing, so it's not waived at this point. It may be waived after he fills out some forms, probably having to do with indigency. Okay?
Good, Your Honor.
All right. All right, next is Christopher Logan.
He's in North Broward, Your Honor. I spoke to Mr. Logan this morning. This is,
You bonded?
Yes, his bond was posted, Your Honor.
Okay. There's that one. All right. Next is Nelson Giraldo. Where's he, Maine?
Maine, Your Honor.
Okay, there's Mr. Giraldo. Possession of cannabis, possession with intent to sell cannabis, drug paraphernalia, driving while license suspended, first offense, and no tag light, which is an infraction. And let me just look through this here. All right. Marijuana residue. And with identifying them by the flavor. He had 19 grams inside the glove compartment. $401. Possession of marijuana over 20 grams, even though he only found 19 grams. How is that possible? That he's charged with possession of marijuana over 20 grams when the probable cause affidavit only shows that he had 19 grams. I'm just wondering.
2 grams inside of a gold container.
He had 2 grams where?
Inside of a gold container.
Okay, where was that?
The probable cause affidavit.
No, but where was that container? In his pocket, in the glove box, in the car? Because I'm looking for that information. Where is it on the probable cause
It's on
affidavit?
page 2, last paragraph.
Okay, let me take a look at that.
Search revealed.
Oh, yeah, here we go. Approximately 2 grams. Okay, well, I'm going to find probable cause. So, his total bond as it sits now is $2,200. State?
He's not seeking a bond increase.
And defense, can he bond out?
No, he can't, Your Honor. We'd be requesting standard pretrial or ROR if the
All right,
court's so
well,
inclined.
before I do anything like that, I got to know a little bit more about him. Tell me something about him. Something good.
I lived in Florida 23 years of my life. I previously lost my company of pressure cleaning. I'm starting school in August, a barber school. I've been here. I have family here. I have a little sister and a little brother. My mom and my father, obviously. But I've lived here all my life. I've never sold any drugs or anything like that. So
State, any priors? Did I ask you that?
2016 drug paraphernalia, a 2017 possession of cannabis, and a 2015 battery.
Okay. So he can't afford any bond?
not at the moment. I don't have any income at the moment.
You're staying at your parents', you said?
Yes, sir.
And your parents' address is
320 Northeast 45th Court, Oakland Park, Florida.
let me just check the probable cause affidavit here. Yeah.
320 Northeast
45th Court.
And what are you doing for work though?
I previously was washing cars, but like I said, I lost my business. I literally just sold my trailer this past weekend.
So what are you gonna do for work so that you can, you know?
I'm getting my high school diploma as we speak, and I'm going in August. I'm starting barber school.
Okay. Looks like he's a 6 on the overall risk potential for. What does that mean, Trey?
Let me see the actual bargain.
Yeah.
When we filled out his assessment, the assessment brought back that he was a medium risk level.
Medium. All right. I'll put him on pretrial release, level 2. What's that?
GPS level 2, you're putting him on electronic monitoring?
Yeah. I'm going to put him on electronic monitoring just to make sure that he's either home or at work and church
So
or
that's
the
an
grocery.
ROR on all counts, Judge?
Yeah. What about that? How about some drug testing? How's that sound?
That's fine. I only have marijuana in my system.
He has no problem with drug testing, Your Honor.
Is marijuana gonna fail him on his, yeah.
Could we get a deferment or something to not test for a couple months? However long.
They'll wait. They're gonna wait automatically, and then they'll randomly test you for marijuana, okay? So, for everything, yeah, including marijuana. So, you gotta stay clean, okay?
Okay.
All right,
Thank you, Your Honor.
all right. All right, next one I have is, Earl Outlaw,
He's out on medical loan.
medical loan, okay? So this one's medical. Next one is, Dimitri Nozil, medical, okay? And the next one is Solomon Terry. He's where? All right. And is this one of the ones that I had, the supplemental,
Correct, it's a change of charge.
Solomon Terry, and there was one for Timothy Hall. What did we do with Timothy Hall? Reset it.
No, he
No.
was given level 1 GPS.
Level 1 GPS, hold on a second. Okay,
He was given $1,000,
Right.
100,000 on 1 and 2. We left the bond
all right,
at 10,000.
right, all right. Here's the booking report that goes with Timothy Hall. All right. All right. So Terry Solomon, what do we got here? His risk potential is 5 for pretrial. He's what?
He's a medium.
Medium, okay. He's charged with throwing a missile into a dwelling, ag battery with a firearm, both of those with a firearm. And then he's got 4 capious felonies.
Yes, Your Honor, in count 1 and count 2, they were actually upfiled to more serious crimes.
Oh.
Each one of those counts carries a 25-year mandatory minimum. And there's already bonds that have been set by Judge Malika in those
More
counts.
serious charges?
Yeah, well, it's been upfiled since she set the bond amount, but the
What was,
state is,
what was the bond she set?
on count 1, it was an improper exhibition of the firearm. It was $50,000. The ag assault with a deadly weapon was $25,000. And then, which would be count 3, the grand theft of the firearm, $25,000, and then count 4 and 5 both were $100,000. So the state at this time is not seeking any modification
Okay.
of those amounts of bond, but I do want to inform the court that these crimes, or the charges, were upfiled to more serious crimes.
All right, public defender?
Just so we're clear, because the way they have it listed on the docket, they have it as 1 through 10.
Right.
And so what I just want to make clear, it's that 1, 4, 5, and 7 are on one face sheet, and then there's another face sheet that has 1, 2, and 3, but I think those are 8, 9, and 10.
All right, so let's do it this way. I see a capias here, and the reason we have a capias is because of the upcharge, right? Since the charge was changed, a capias issued on the new charge, correct? State? Defense? Correct?
Yes,
All
that's
right.
correct, Your Honor.
So count 1 is an aggravated battery with a firearm, and count 2 is an aggravated battery with a firearm, and each one of those, tell me what the bond is.
That would be $100,000 for each one of those counts.
Okay.
Can you afford it?
I'm reading the capias. So I'm setting the bond per the capias, because that's what I have to go by, right?
The counts are
Read the face sheet on top.
The
Because
face
that's
sheet
what we
says
don't-
count 1 is throwing
Yes, that's what-
missile into a
yeah,
dwelling. Okay, and that one has a bond already of what?
That has a bond of,
Dwelling/vehicle, it's,
yeah, 50,000.
all right, and you wanna leave that the way it is, right?
Yes.
All right, count, what's that? All right, then we'll leave that on place as well. Ag battery with a firearm, which is shown as 4 on the face sheet. What's the bond on that?
$100,000.
Okay. Ag battery with a firearm, second count, which is count 5 on the face sheet.
Yes, $100,000.
Okay. And then I have a count 7, 8, 9, and 10. What are those? Those are the charges that are dropped? Those are ad charges. Okay, what's the bond on those?
The ad charge, so on count 1, which was changed from improper exhibition of a firearm to shooting or throwing a deadly missile, that was set at 50,000.
Okay.
State would request that remain the same.
All right. So on the KPSs that are on here,
It's count 7, Judge.
you count.
Said 1, but 1 is 7 on the face sheet.
1 is 7 on
Let's
the
keep
face
going
sheet.
on the- Yeah, 7. So 7. You was ad charge for 7, which is shoot into occupied dwelling. Count 8 is a possession of firearm by a convicted felon. Count 9 is a possession of firearm by a convicted felon.
And those currently have no bond.
Correct. They're home for they're home for magistrate.
Okay. So what do you want to do with those counts?
On those counts, the state would be requesting a $10,000 bond on each of those counts.
So that is an increase in the bond, right?
Those are ad charges.
Okay. And tell me what they are again. I'm sorry to bug you again with that. But my sheet doesn't show it.
Shoot into an occupied building.
That's count 7? Okay.
Count 8.
Shooting into an occupied building, that's a second-degree felony, correct? State?
Yes, that is correct.
All right, next.
Counts 8 and 9, Your Honor, are possession of a firearm by a convicted felon.
Okay.
And count 10 is discharge firearm from vehicle.
Is that a third-degree felony or second-degree? State, it's up to you.
That is a third degree.
Okay. All right. So let's start from the bottom up. On the discharge of a firearm from a vehicle, I'm going to set that bond at 1,000. On the possession of a firearm by a convicted felon, is that a third degree or a second degree? State.
That is a second degree.
Okay, so I'm going to set each of those bonds at 5,000. And then on the shooting into I think it was an occupied building, that is a second-degree felony, so I'm going to set that at 5,000. So looking at the face sheet, missile into a dwelling or vehicle, 50,000. Ag battery firearm, 100,000. Ag battery firearm, 100,000. The shooting into a dwelling, 5,000. The possession of a firearm by a convicted felon, 5,000. The second possession of a firearm by a convicted felon, 5,000. And the discharging a firearm from a vehicle, $1,000. You got all that? And I'm going to find probable cause.
Your Honor, counts 1, 4, and 5, you're adopting the
I am. I'm not changing any of
What
what.
was the bonds on count 5? Count 5 was 100,000. Thank you.
Here, I wrote it down on the side over here. I just wrote them down on the side there. Okay.
Just missed one.
All right.
50, 100, 100.
All right. Does that conclude our magistrates for the day?
Your Honor?
Yes.
Maybe I wasn't able to hear, but we would be requesting pretrial release on an ankle monitor. The defendant doesn't have resources above $1,000.
All right. Well, the division judge can take that up when he files a written motion and tells him all the good things he can come up with to tell him to try to get his bond reduced. Okay.
Very good. Thank you, Your Honor.
Okay.
For 7 through 9, you're
Just monetary. Yeah. All right, thank you all. Is that it? I won't.
Yeah, thank you, Judge.
All right. Well, that went smoothly.
Not bad.
Nope. Now I can go up to my office and do some more work if I want. I was here until 8 o'clock last night in a trial. I'm in a 3-week-long trial, so.
And
A tobacco civil case.
oh, ooh. So you're still in the middle of it?
Yep, week 2, just finished. Sure. Yeah. Well, nothing's off the record any.
Referring to the case that I was interpreting,
Uh-huh.
when Your Honor said regarding my interpretation of the charge, and what happens is the interpreter is giving a word, and the interpreter is going by the instructions to the jury
Right.
to get the interpretation
Right.
equivalent.
What was the word, do you remember?
The sexual assault.
Assault, okay.
And so for the interpreter, assault is the attempt.
Yeah, assault is not an attempt. It's a touching.
So the interpreter, if the interpreter could have more information so that then she can make the relevant change
Right.
of the word, because the interpreter can't infer without having that information as
Mhm.
to whether it is an attempt or not.
Yeah, an attempt versus an assault, an assault implies a touching. So an attempt would be trying to touch versus touching.
And so as the interpreter.
If you see assault, it's usually a touching, I think.
That's, I would really.
Let me
like
see what the
to-
charge was.
to- No, because,
Let me see. Sexual assault by a 24-year-old, sexual battery victim 16 or 17. So, asaltar?
Asaltar is a different meaning. That means hold up.
I don't know.
It's a false cognate, Your Honor.
Asaltar
Yeah.
sexualmente is what I would say. But that's what I would say. I'm not the official interpreter, though.
Yes,
You are.
It's
But it's a battery. It's a touching. It's not a.
Okay, I guess I'm going to
Yeah.
bring it up to my supervisor.
Yeah, ask her about sexual assault, how you translate
We
sexual.
are all doing the same thing.
Right.
Because when we look it up, like here, for example, sexual assault is.
And assault is not an attempt, under any circumstances.
So assault as opposed to, say, sexual battery.
No, a sexual assault is a, state, when you charge something as a sexual assault, isn't it the same basically as a sexual battery? What's the distinction? Okay, so battery would be penetration, and assault would be a touching?
The attempt, that's how,
The attempt to touch, okay. Well, maybe you're right.
that's how, because we don't have all that information, so we can only go by the instructions to the jury in the word assault.
Now, if you ask the public defender, they'll tell you it means it never happened.
We
That's
have
why.
someone over there who speaks Spanish.
Right. Yeah.
Okay. Oh, but the interpreter is when you're sitting down because.
Yeah, try to work that out, because I'm not sure how you translate it. Because I would translate it as a, an actual touching, and it's being translated as an attempted touching.
Yeah, I found, this is an attorney giving an explanation of the difference between assault and sexual assault and sexual battery.
Mm-hmm.
And he's saying that it's is the attempt by threatening a person.
Okay. Well, whatever you work out as the official translation is fine. All right, you guys need anything else? You're all set?
Yeah, thank
You
you.
got all the paperwork over there? You're good? Okay. All right. Can I give you back all your risk assessments so you can have those, or do you want me to just throw them away? All right, yeah, why don't you shred them? Bye-bye. Now, what I want to know is how you get a stapler like this. This is a real stapler. The ones they give you now are all these little plastic ones that you try to punch through. Yeah, maybe somebody bought this themselves. Last two?
Yeah, that's the one where it was $100,000 bond on each account. The one and two. We got some good. Great. And then there was the aggravated battery with the deadly weapon and just was floating. Yeah, and it's open about it.
All right, we'll see you tomorrow. Same time, same place. Yep. Same people coming tomorrow? Same group?
Same PDs, different state.
Different state? Okay.
They change.
I'm just gonna leave my road here. Nobody else is gonna use it. All right, see y'all tomorrow. Bye-bye.
Right, right. Yeah. No.
Yeah, is it the road board?
Oh, okay.
Oh, yeah, they did. I, which